Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
I didn't ask you to interrupt.
Is that correct?
Dati mihi Anglican, from sake.
Good morning. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. We made it. We made it through the weekend. At least some of us did. It was a little rough for me. I think I pushed myself a little too hard on Saturday and was down for the count yesterday completely. All right, welcome. Let's see. Why is that not working? There we go. Congratulations, Kim. Well, I would say congratulations, Kim, but it's not working. Kim, before I can award you the internet, I need you to fix the internet. Oh, I fixed it. It's on my end. Never mind. I apologize. Nice and bright in the studio. It's a little sunshiny. It's a tiny bit, like a little much, actually. Okay, let me bring Kim on. There's Kim. Let me make it a little darker because it's a little bright today. There we go. Let's turn it down a little, you know. As I knock everything over on my desk. Okay, lights, are they going to stay on? No. I'm not sure what today is about, but here we go. Lights are green and they might go off. I don't know why. All right, they're doing greeny things. Good morning, everyone. We're gonna talk a little bit about a trial. Interesting little hearing. They call it a trial. A little different though, because it starts out with the defendant being guilty. So you're like, what? We'll get to that here in just a minute as that goes forward. All right. I have to do birthdays first. Let's do birthdays. Sorry, sleeping the way the day yesterday was a little rough to catch up from. All right, looks like we have beautifully shattered Candy, Katie, Logan, Nola, and Obi Ham all celebrating their birthday today. So everyone stand up, take a deep breath, put your shoulders back, project your voice to the back of the room, blend your voice with your neighbors. Warm up with me, if you will. La 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 la. That's good. We'll sing happy birthday to these wonderful folks. Happy birthday to you. Happy birthday to you. Happy birthday, beautiful shattered Candy, Katie, Logan, Nola, and Obi Ham. Happy birthday to you.
Happy birthday. You look good.
Thank you, Judge Fleischer. Timing was perfect. Impeccable timing, actually. Let me send this over here. It's Monday. I'm just still waking up, guys, if you can't tell. I apologize. For those who are celebrating, happy birthday. I realize there are a million places you could be, a million people you could be with. You chose to be here and celebrate with us. The privilege, the pleasure is ours. Thank you very much. Thank you. Hopefully we can return some of that joy, that pleasure, that wonderfulness back to you and make your day a little more specialer. Help yourself to fruit pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, and Bob Evans. There we go. And with that, we're going to let the dancers wrap up here. They're the free pancakes. I see that. Melanie, thank you. Serving everybody a free stack. Let's see. Boom, 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 boom. I like it a lot. Mullis in the barn with the corn rake doesn't appear in my clue game. What does air drum big finish on the birthday song appear? Because we're going to do it. Everyone grab your air drum stick, sit down to your air drum set. Here we go. Beautiful, beautiful. Thank you. I know why I'm late this morning. It's because Mrs. R.A. is on vacation. So I slept in. She took the wee ones, all the school age children, on an extended field trip. So I think she'll be back tomorrow night, which is good because I'll be starving by then. 2 days with no food, so I'll have to cook it myself. Good stuff.
When are we going to break for lunch, Judge?
All right, let's see. Noisy court, check. Okay, well we'll get there in just a minute. Let's see, I don't know what we're going to be counting, though. That's what to count. I pray you survive. I've got kids as still in the single digits, and some kids as all the way up to the early 20s and married. So... Pickles and grilled cheese today. Whatever's in the fridge is what's going to be on the menu, I think. Background of this trial. This is where we're going first. Let me do this. As a matter of fact, I don't mind being late to trial today to read you what we have here. And let me see if I can bring it up on... Come on. AirDrop to my computer. This is where you show up on my computer. At least that would be nice. Send it again. Oh, there it is. All right. Put this up right here on 3. Make it full screen. We haven't done a little reading in quite a while. We have a little reading to do today. A little bit of reading to catch everybody up on what is going on in Iowa. And why we would have another case today. Okay, can you guys see this? Yes? Looks good. Let me get rid of this comment here really quickly. Vicky Mack, 15 months. Max Pritchett was just in McBurney. I was not in McBurney. I was not. Do you have a picture? All right. Let me get. Oh, that's the problem. My chat is only showing top chat. I need live chat so I can see everything. There we go. Jamie Jane, 22 months. I followed this case during this first trial. Excited he got a new trial. This was a wild case. Glad we're following up. Iowa and corn rake. Sounds about right, says Northwest. Watch this first time. Feels like a long time ago. 4 years, right? Wasn't it 4 years ago? Chipmunk Chewy says, I'm in Iowa and didn't know this was happening. This is right down the road from me. Good morning, late start. Okay, we've got some reading to do. Ready? Let's get this up on the big screen so we can read this. Appeal from the Iowa District Court for Delaware County, Thomas A. Bitter, Judge. Todd Mullis appeals his conviction for first-degree murder. Affirmed. That's you always want affirmed on when you get an appeal if you're the defendant. Let's see. We've got the lawyers on there for the appellant, the attorney general. There's my mouse. Okay. Senior judge heard this case pursuant to the law. Oops. Why are we scrolling so fast? Let's do continuous scroll. There we go. All right. Todd Mullis appeals his conviction. Yes, conviction. Todd Mullis has been convicted already of the crime that we are about to hear him. But he's getting a new trial. Appeals his conviction for first-degree murder following the death of his wife, Amy Mullis. On appeal, he challenges the denial of his motions for judgment of acquittal and a new trial. We affirm. Facts and prior proceedings. Todd was passionate about his wife. No, Todd was passionate about farming. He loved farm life and worked very hard. Todd purchased his first farm in 1999. Eventually, Todd's operation grew to 3 farms and part of another. That would be 3-point-something farms. Todd's farm includes 2 hog barns on his home place. I'm gonna have to use the stress cow up here for a little bit because we're talking about farms, even though he's got hog farms. Todd's farm includes 2 hog barns on his home place. Todd met Amy. Guess where else? You can't make this up. Todd met Amy in 2003 at the Delaware County Fair. They married in 2004. Following marriage, Amy moved on to Todd's farm. However, Amy worked off the farm in healthcare. Eventually, the couple had 3 children, but they also had their challenges. Around 2013, Amy had an affair with someone she met at work. The couple entered counseling at the encouragement of a mutual friend and reconciled, and Amy left her job and became a stay-at-home parent. Amy had to be accountable to Todd and let him know if she had to go somewhere. According to Amy's stepmother, Todd resolved to work things out and told Amy's stepmother, "I'm not going to lose my farm and what I've worked for." Are you seeing a common theme here? Okay. Things came to a head in 2018. The year was full of difficulties. In June, Amy began a second affair, this time with Jerry Frasher, who oversaw the farm's hog operation, the big farmer. Todd became suspicious of the two after reviewing a phone bill and noting a significant amount of contact between Amy and Frasher. So Todd confronted Frasher, who denied the affair, but Todd was unsure whether Frasher was telling him the truth. So Todd contacted Frasher's wife and shared his suspicions with her. She thought Todd was crazy. Todd called back a couple days later and apologized to both of them. He also shared his suspicions with Amy's stepmother. And Todd questioned their mutual friend, Amy's former coworker, about Amy's behavior and indicated she was acting like she had during her first affair. At one point, their friend suggested the two might be better off not together, but Todd responded, "I've worked for this farm since I was 11, and I will not give it up." This is the third time we've heard this. When their mutual friend learned of the affair from Amy, she told Amy, "You're putting yourself in a really dangerous situation," and expressed concern stating, "Todd is going to kill you because Todd is just the person you don't mess with." Their friend was at a work event and heard rumors of the affair, so she told Amy about the rumors, and Amy became upset. Amy then told her where to look for her body if she should go missing. I'm guessing it's the pig farm. Amy contacted another former coworker to see if she had heard rumors of the affair and asked her to stop any that she might hear. Amy explained several times that Todd would kill her if he found out, and explained her eldest child, TM, had told Amy, "If Dad finds out you're going to have an affair, he'll kill you." By July, Amy had talked to their mutual friend about leaving Todd, and Amy was to the point where she felt like she was strong enough to leave on her own, and it was not so much anymore she would leave for Frasher, but she would leave on her own. So she wasn't leaving for the pig farmer, she was just going to go out on her own. And Amy said she was quietly looking for jobs and somewhere to live. That same month, Amy explained to another friend that Todd did not want to divorce because he would lose half of everything, and it is socially unacceptable. There's the fourth time. Lose the farm. On another occasion, Amy explained to her that she was scared of Todd, and if he found out about wanting a divorce or an affair, that he would kill her. Then Amy's grandmother passed away in August. According to Amy's brother, by then Amy was planning to divorce Todd and expecting Todd to flip out. But Amy's worried that TM, their child, would be angry for her leaving Todd. Amy asked her brother to store some of their grandmother's furniture so she would have somewhere she would have some when she left Todd. At the end of the month, Todd confided in their mutual friend and explained Amy told him there were rumors about her having an affair. And then she cried for hours, and she said she would leave because we are better off without her. In October, Amy's uncle suffered a brain bleed, so Amy was away from Todd and the children frequently to help with her uncle's care. And her absence began to wear on Todd as he had hogs going out plus the harvest and had to care for the children at the same time. That month, Todd found a corn rake in the yard and put it in the red shed. Amy had an outpatient medical procedure on November 6th. Upon discharge, Amy had a 10-pound lifting restriction and rested at home for a few days. A friend texted Amy the morning of November 10th to see how she was doing. Amy responded, "Thanks, okay. Things still very tense around here, just not sure of anything anymore." The couple's mutual friend described the procedure as an ablation, which she says was performed to treat heavy menstruation. There you go. Fun facts. We've got all the details today. That morning, TM and Todd... Well, the garbage man finally came by. He's like 4 days late. Okay. That morning, TM and Todd had left the house to check on some hogs outside. When they returned to the farmhouse for breakfast that Amy had prepared, after breakfast, TM and Todd went out to the north hog barn on the farm. The barn was as large as a football field. At 10:12 a.m., Amy emailed Frasher, "Do you know what I'm doing today? Cleaning..." I can't read these words. It's really blurry. "Cleaning light fixtures in the barn. WTF." I think she dropped the F-bomb there. A few minutes later, after TM and Todd went to the North Hog Barn, Amy came out to join them. They worked to prepare the barn for incoming infantile hogs. Are those piglets? Is a baby hog a piglet, or is it a hoglet? Asking for a friend. Todd was arranging nipple feeders in the pens. TM was bringing heaters from a storage area to the pens. Amy was cleaning the light fixtures. Amy cleaned the fixtures while standing on a 5-gallon bucket. TM and Todd noticed Amy seemed unsteady and both asked her if she was all right. Amy continued to work but appeared unsteady, so both TM and Todd suggested she stop working on the light fixtures. Todd suggested Amy would go get a pet carrier from the red shed, which was about 30 yards from the front of the hog barn. The pet carrier weighed 10 to 15 pounds. Todd asked Amy to either take the pet carrier to the shop building across the yard or leave it out for them. TM and Todd continued to work in the hog barn for about another hour and a half. After Amy left, TM took over cleaning the light fixtures. At some point, TM lost sight of Todd while they were in the hog barn, but was unsure how long that was. This child is going to be key to this case. TM was out of Todd's sight when he stepped into a small office in the corner of the barn to get a drink of water a couple times. The 2 youngest children remained in the home. Initially, TM told investigators that he was with Todd the entire time. Then at a deposition, TM said he was out of Todd's sight for 1 minute and 40 seconds. Oh. When Todd noticed the pet carrier was not in the yard or in the front shop, he sent TM to get the pet carrier out of the shed. TM went into the red shed and found Amy on her hands and knees, face down, with the corn rake sticking out of her back. TM yelled for Todd. Amy was unresponsive. TM checked whether Amy had a pulse or was breathing. Todd ran over and told TM to get the truck and bring it over. Todd did not render aid or call 911 while he waited for TM. When TM brought the truck over, he saw Todd pull the corn rake out of Amy's back. TM got in the passenger side of the truck. Todd put Amy on TM's lap, and they set off for the hospital. While driving, Todd called 911 at 12:01 p.m. and said Amy fell on a corn rake. The operator told Todd to pull over and perform CPR, which Todd did. Deputy Luke Thompson arrived on the scene and took over CPR. He asked Todd what happened, and Todd told him they found her with a corn rake in her back. An ambulance arrived on the scene, as did some bystanders who knew the family. TM went back to the family farm with one of the bystanders. Todd went with another bystander and followed the ambulance to the hospital. At the hospital, Amy was pronounced dead. A medical examiner completed an initial examination of her remains and discovered, count them, 6 puncture wounds on her back. The medical examiner also observed injuries to Amy's chin, cheekbone, knees, and knuckles of each hand. The injury to Amy's chin had both crush and scraping components to it, but there was no debris in the wound from hitting a surface. Let's see, it says, but he later clarified with the state and defense counsel that his estimate was inaccurate. He could not estimate how long Todd was out of sight. Because Todd reported that Amy fell on the corn rake, the medical examiner asked to see it. When the examiner discovered the rake had 4 tines, 4, that's less than 6, he questioned how it could create 6 puncture wounds with 1 impact. So he contacted the state forensic pathologist and requested she perform an autopsy of Amy's remains. Meanwhile, deputies followed TM back to the family farm where TM showed them the red shed where he found Amy. That evening, Delaware County Deputy Sheriff Travis Hemisath was briefed on the case by Deputy Tom Thompson, who took Deputy Hemisath out to the family farm to investigate. 2 days later, Deputy Hemisath attended the autopsy performed by the forensic pathologist. The forensic pathologist determined the damage to Amy's left hand could be defensive wounds, consistent with a struggle, and that she had blunt force trauma to her chin, cheek, and ear. When examining the puncture wounds to Amy's back, the pathologist discovered 2 different wound paths. So the pathologist reasoned Amy was impaled with the corn rake at least 2 times and possibly 3 times. And the pathologist found the corn rake penetrated through Amy's back deep enough to rupture her breast implant and exit her front side. Oh my goodness. As well as puncture her liver, her lung, and liver. So the pathologist classified Amy's manner of death as homicide. As part of this investigation, Deputy Hemisath executed a search warrant and took all of Todd's electronics, including a camera system with 2 cameras covering the property. No video from the camera pointed at the red shed could be recovered, and video from the camera pointed at the yard between the buildings spanned September 11th through October 29th, and then picked back up on November 11th, the day the camera system was confiscated. Let's read that again. The video from the camera pointed at the yard between the buildings spanned September 11th through October 29th, and then picked back up on November 11th through the day the camera was confiscated. So it's conveniently missing the chunk where she fell. But investigators could not determine if the missing video was deleted. Deputy Hemisath also collected Todd's iPad that was located in his tractor at the time. Deputy Hemisath discovered that earlier in the year, the Google account Todd used on his iPad was used to search for things like, did ancient cultures kill adulterers, and thrill of the kill, thrill of the hunt, famous quote, no thrill like that of hunting man. Once you hunt man, you will always feel the thirst. What happens to cheaters in history? Killing unfaithful women. What to do with large open chest wounds, and organs in the body. Yeah, just regular stuff. Following the autopsy, Deputy Hemisath contacted John Turbett, a special agent with the Iowa Division of Criminal Investigations, to assist in his investigation. Special Agent Turbett investigated Thrasher, with whom Amy had had the affair, and eliminated him as a suspect. Special Agent Turbett also eliminated Thrasher's wife as a suspect. Special Agent Turbett then interviewed Todd. Todd described his marriage to Amy as great and said they had a very healthy marriage. Eventually, Special Agent Turbett confronted Todd and accused him of killing Amy. Todd responded by asking what evidence he had and asked Turbett to tell him what the police knew. He told Special Agent Turbett, "You want me to confess to something I didn't do?" During the interview, Todd was unemotional and very flat. We acknowledge other family members had access to Todd's iPad and knew the password, but a rational jury could find Todd was the one who performed these searches. Eventually, Todd was arrested for Amy's murder, and the matter proceeded to a jury trial. Todd moved for judgment of acquittal following the state's presentation of evidence contending the state failed to present evidence Todd committed the act that killed Amy. Todd testified in his own defense. During cross-examination, Todd conceded that Amy's death was not an accident, and someone stabbed Amy in the back with a corn rake 2 or 3 times. Todd renewed his motion for judgment of acquittal following his presentation of evidence. The jury convicted Todd of first-degree murder. Todd motioned for a new trial, which the district court denied. Todd appeals, claiming the district court erred when it denied his motions for judgment of acquittal and abused its discretion in denying his motion for a new trial because his conviction was not supported by sufficient evidence. Additional facts will be discussed as necessary. Part 2, scope and standard of review. The principles governing our review of a district court's denial of a criminal defendant's motion for judgment of acquittal are well established. Case law, State v. Serrato. A motion for the judgment of acquittal is a means of challenging the sufficiency of the evidence and will review such claims for correction of errors at law. Guilty verdicts must be supported by substantial evidence, which is that upon which a rational trier of fact could find the defendant guilty beyond a reasonable doubt. Though we consider all evidence, we view it in the light most favorable to the state, so evidence is not insubstantial merely because we may draw different conclusions from it. When reviewing rulings on motions for a new trial, we recognize trial courts have wide discretion deciding motions for a new trial. Iowa Rule of Criminal Procedure permits a district court to grant a motion for a new trial when a verdict is contrary to the weight of the evidence. The weight of the evidence standard requires the district court to consider whether more credible evidence supports the verdict rendered than supports the alternative verdict. The question is whether a greater amount of credible evidence suggests the verdict rendered was a miscarriage of justice. As we review the district court's determination for an abuse of discretion, Motions for judgment of acquittal. We first addressed Todd's contention that the district court erred in denying his motions for judgment of acquittal because the state failed to present sufficient evidence to support his conviction. Todd generally attempts to poke holes in the state's case and essentially attempts to retry the case for a different audience on appeal, but those efforts are futile. It is not for us to independently weigh the evidence to reach our own conclusion as to Todd's guilt. This is the appellate court talking here. Instead, we proceed by viewing the evidence in the light most favorable to the state to determine whether it has presented substantial evidence of Todd's guilt, evidence that a jury could rely on to find Todd guilty beyond a reasonable doubt. In doing so, we break down the offense, murder in the first degree, element by element. Where, as here, the jury was instructed without objection, the jury instructions are the law of the case for the purposes of reviewing the sufficiency of the evidence. The marshalling instruction provided, cow bailed. Cow's done. He went to, what do you call it when they go on their back? Feet up. He went feet up. Okay, so the instructions, we can skip through some of this, but basically the state said that she died on the 10th day of November, the day before the camera system turned back on. The defendant committed an act upon Amy Mullis. That's what they allege. Amy Mullis died as a result of the act. The defendant acted with malice aforethought, that planned it out. The defendant acted willfully, deliberately, and premeditatively with the specific intent to kill Amy Mullis, and on appeal, Todd attempts to challenge the sufficiency of elements 1, 2, and 4 of the marshalling instruction. But the state contends Todd only adequately preserved an error as to the first element, identity. When he doesn't preserve error, that means they don't object in a timely manner and preserve it for the record. If you don't object, you can't later go back and say, wait, they did that wrong. It's like you didn't complain at the moment. If you don't call a foul when it happens, you can't go back and, flip the game because you didn't call the foul. All right. To preserve error on a claim of insufficient evidence for appellate review in a criminal case, the defendant must make a motion for judgment of acquittal at trial that identifies the specific grounds on appeal. So we must first consider whether Todd adequately identified specific grounds related to each of the challenged elements in this motion for judgment of acquittal before we may consider them on appeal. With respect to the first element, that was identity, we agree with the state that Todd adequately challenged identity to preserve a challenge to the first element. With respect to the second element, Todd now claims Amy died as a result of a tragic accident, not the result of another person's actions. But Todd never argued this ground when making his motion. Todd acknowledges element 3 that he acted with malice aforethought is a necessary element of the offense, but he does not specifically challenge the sufficiency of the evidence with respect to that element. So instead, Todd's counsel conceded Amy died obviously as a result of criminal behavior. So his challenge to the second element is not preserved. With respect to the fourth element, which requires evidence Todd acted willfully, deliberately, and premeditatively, and with a specific intent to kill Amy, we do not think Todd's motion raised an adequate challenge to preserve the issue for appeal. And the obvious understood exception to our error preservation rule does not apply. All right. Accordingly, we limit our review to determine whether there is sufficient evidence that Todd was Amy's assailant. Big footnote. Ready? Todd claims he never authorized his counsel to make such a concession. This is saying that they agreed that she was killed, obviously, by an attacker, not an accident. Seemingly assuming this will permit him to argue Amy died as the result of an accident on appeal. Even if that were true, Todd himself conceded on cross-examination that someone killed Amy, and the evidence presented at trial established Amy died as a result of intentional conduct, not a tragic accident. Moreover, she had defensive wounds on her hand. Her chin, injury, absent of any debris, was consistent with being struck by someone as opposed to falling onto something, and the corn rake punctured her back at least 2 times. This evidence is indicative of an attack perpetrated by one person on another, not merely an unsteady person falling onto a sharp object and fatally injuring themselves. Even if Todd had preserved this issue for appeal, we would conclude the state presented sufficient evidence of this element. The internet searches on Todd's iPad show was planning to murder Amy. They messed that sentence up. Todd was planning to murder Amy. Todd was aware of her affair and did not want to lose his farm in a divorce. The evidence established Todd impaled Amy at least 2 times with the corn rake, went back to work in the hog barn, and left Amy to die in the red shed. From this, the jury could determine Todd's conduct was intentional and not accidental, making his conduct willful. And Todd impaled Amy multiple times, necessarily giving him a moment in between blows to consider his actions and resolve himself to strike again. So the evidence is sufficient to support the finding Todd acted deliberately with premeditation and with specific intent to kill. We're almost done. Then we're going to jump to court. Reviewing the evidence in the light most favorable to the state, we conclude there was sufficient evidence to identify Todd as Amy's attacker. Though not a required element to the offense, we recognize Todd had motive to kill Amy. Witnesses testify that Amy was getting up the nerve to leave Todd, but Todd was staunchly against divorce because it would put his cherished farming operation at risk. The state also presented evidence that Amy, TM, and a family friend believed Todd would kill Amy if he learned of her affair. And rumors were running through the community. Todd admitted he was suspicious of the affair even after he confronted Thrasher about it. The jury could reasonably conclude that Todd learned of the affair, Amy's plans to leave him, or both, and resolved to kill her either in an act of vengeance or as an attempt to avoid divorce and preserve his assets. From the evidence presented, it was clear that either would serve as a strong motivation for Todd to act. Getting down to brass tacks, only Todd and TM knew Amy would be in the red shed when she went to move the pet carrier. TM never left the hog barn, but he did lose sight of Todd while they worked, and TM could not say how long Todd was out of his sight. The 2 youngest children were inside the home the entire time. Both TM and Todd testified that no one else was on the farm that day, and Todd never heard anyone drive onto their rural property, so there are no other potential assailants. Todd argues it would be impossible for him to run 50-plus yards inside the hog barn, exit a double-latch door on the east end of the barn, sprint 150 yards to the red shed, murder Amy with the corn rake, and run back in the time it took TM to get a drink. But Todd's argument rests on a faulty premise because TM could not say how long Todd was out of his sight. This provided a window of opportunity for Todd to slip out of the barn while TM worked. Todd relies strongly on TM's testimony that Todd did not appear winded or upset when he saw him again. Here, young TM was just in 8th grade when he testified at trial almost a year after the events in question. Given his young age and the trauma he has no doubt experienced as a result of this incident, no one would expect him to remember the day with perfect recall, and juries are free to weigh the credibility of witnesses and believe some, all, or none of a witness's testimony. So TM's testimony about Todd not appearing winded or upset is not dispositive. What is clear from the evidence is that only TM and Todd knew where to find Amy when she was attacked. Todd had ample motive to harm her, TM never left the hog barn, and he lost sight of Todd while they worked. Other than the younger children, there is no evidence anyone else was on the farm that fateful day. From the evidence presented, Todd is the only possible assailant. So we conclude the state presented sufficient evidence that Todd was Amy's attacker, and the district court promptly denied the motions for judgment of acquittal. Another big footnote. See. Chem Lady says, I missed your birthday shout out, but turned 70 Saturday. Chem Lady, happy birthday. Happy 70th. That is awesome. I'm sorry I missed it. I missed a lot right now. Let me see if we're almost done with this. We'll see what I missed. All right. We note Todd takes issue with the state's reference to a recording of the 911 call Todd made. The state claimed Todd could be heard whispering, cheating whore, and go to heck, you cheating whore, as he performed CPR on Amy. Okay, we're going to have to do some audio work on that. Because that's a little much. Usually you're supposed to say, staying alive. The whole cheating whore, go to... Yeah, no, I don't think it's got to be mistaken. That's not the rhythm. That's not the rhythm of CPR. Todd denied making these statements during cross-examination, so he claims without evidence to contradict his testimony, we should disregard the state's arguments as it relates to the 911 call. But the recording of the call was admitted into the record, so the recording itself serves as contradicting evidence. It is clear from the recording, Todd mutters something under his breath as he performs CPR on Amy. And while it is barely audible, I can fix that. It was consistent with Todd calling Amy a cheating whore and telling her to go to hell, cheating whore. All right, there we go. The recording of the 911 call, now we have to go down here to the bottom, was in evidence, but the jury could listen for themselves and believe or disbelieve what the prosecutor presented to be on the recording. But even without consideration of this evidence, there is sufficient evidence to convict Todd. Now back up here to the top. Motion for a new trial. Now we need to watch the first trial. Todd also claims because there is insufficient evidence to support his conviction, then the district court necessarily abused its discretion in weighing the evidence and determining the weight of the evidence supported the conviction. From the get-go, we disagree. As previously discussed, there was sufficient evidence supporting Todd's conviction. When ruling on the motion for a new trial from the bench, the district court stated, I would say I think I'm actually required, or at least that I should independently weigh the evidence and consider credibility as it pertains to a motion for a new trial. If the verdict is contrary to the weight of the evidence, the defendant is entitled to a new trial. I cannot say that the evidence in this case or that the verdict was contrary to the weight of the evidence. That was a little convoluted. I might need some water. So the court applied the correct standard and independently weighed the evidence. And from my review of the evidence, we believe it was not impossible for Todd to commit the crime as he claims. Further, we find the greater weight of the credible evidence establishes Todd was vengeful over Amy's infidelity. He researched how to kill his wife on the internet, because the internet has everything. He planned her murder to avoid losing his farm in a divorce. Todd took advantage of the opportunity when his weakened wife went to the shed where he stored a corn rake. Todd slipped out of the barn, assaulted Amy, impaled her at least twice with the corn rake, and returned without being noticed by TM, who was busy cleaning ceiling lights. Later, Todd sent TM to find Amy. We conclude the credible evidence weighs in favor of Mullis's guilt. The verdict rendered was not a miscarriage of justice. The district court did not abuse its discretion in determining the greater weight of the credible evidence supported the jury's verdict, finding Todd guilty of murder in the first degree and denying the motion for a new trial. Conclusion. The state presented sufficient evidence identifying Todd as Amy's attacker, so the court correctly denied Todd's motions for judgment of acquittal, and the court did not abuse its discretion in denying Todd's motion for a new trial. Affirmed. Okay, so why do we have a new trial? The state gave sufficient evidence. The court correctly denied Todd's motions for judgment of acquittal, and the court did not abuse its discretion. Hey, Thal, welcome. So with that being said, we need to go jump to court, which I think began just a wee bit ago. Let's see if we can find that here. Okay. There we go. There's our defendant in orange coming in, taking his seat. Waiting for some audio. Let's see what I missed in chat just briefly. Let's see. Scrolling backwards. If they turned him down, what is going on? All I know is that we should have 40 witnesses testify at this hearing. I've heard it's a bench trial. I've heard it's a civil trial. I think there's a mistake somewhere in the description. We don't know exactly what. I need something else up in that window. What's that going to be? Let's do a counter, shall we? All right, so we have a 0. Let's get started. He's just happy to have his day out. It's just a happy camper. And if we do some possibly objection counters, that might be interesting because I don't know. I don't want to count corn rake, right? I did not see the first trial. This was 4 years ago the first trial happened. I want to find a video. As a matter of fact, if somebody on the research team, Mods, I'm looking at you, has a little moment, you don't have to if you don't feel compelled to, but if you're able to find the 911 recording from the first trial and send me a link straight to that, I'll go ahead and bring that in and see if I can clean it up to hear exactly how he was timing his CPR. If it looks tanned, that's what years of work on the farm will do to you. Turns your skin to leather. Trial TV covered the trial and rewatch back in December. Oh man, that's a good one. I think I'll see if I can find it from them. Please do the audio from that call. I'll try. I'll see if I can take out all the noise, clean up the audio, raise the quiet parts, and we'll see what technology can do for us. There was a 48 Hours episode on this. Roro's like, it won't take much cleanup. It's pretty much just there. Okay, let's see if I can find it on Trial TV. They're good friends. Chris won't mind me digging through his copy to see where that audio is. That corn rake is a vicious. Let's see, it's probably going to be day 1 or day 2. Oh, the Google searches. How long can you survive without water? Search for what fraction of firearm incidents occur in the home. He searched for everything. This guy. Oh, hang on. There's another. Doesn't even know what day the 48 Hours has the phone call on YouTube. I need like a timestamp for those that are able to share an exact time. Lego My Briefs, welcome to the Court of Public Opinion. I'm your Lego. Welcome, welcome. No, he's just not a child coordinator. Too soon, Adam. Too soon on that one. Lily, allegedly there was a murder that happened. We're trying to see. Apparently, his wife cheated on him twice, and the second time was once too many. Okay. Let's see here. Looking for more corn rake stuff. There's the verdict. Somebody sent me a link to a pilot who was flying in flight radar. Well, flight radar was tracking the pilot's, path, and you can't see it very well because it's green. But he flew in his plane. He spelled out "Need a pilot?" ? With his flight path in cursive. So apparently he's demonstrating his skills, which is pretty impressive. Loud.
Good morning. We'll go ahead and go on the record. In Delaware, PCCB 009057, Todd Michael Mullis versus the state of Iowa. Mr. Mullis appears in person this morning together with his counsel. I believe the first thing that we need to address is the applicant's motion in limine. There are, I believe, 4 points. Is there any resistance on behalf of the state?
Good morning, Your Honor. I'm just taking a look through it again just to make sure, but I don't believe we have any resistance on that, and we would join the motions as well. Obviously, any undisclosed testimony from their experts, hearsay, things of that nature, we would agree that the rules of evidence and civil procedure control on that.
Thank you, Mr. Bakke. The applicant's motion in limine then will be granted in its entirety.
So these are the ground rules
counsel
for the case.
The applicant, did you desire any further record on that motion for any reason?
No, Your Honor. Ms. Erica Nichols-Cook on behalf of Mr. Mullis today, for ease of the court reporter, we don't need an additional record.
All right. Thank you, Ms. Nichols-Cook. Any other preliminary matters then that counsel wishes to address? Ms. Nichols-Cook?
Your Honor, we briefly talked off record about some exhibits. I'm still talking to the state about that, and we will update the court on the next break. And I think we would request to do a short opening statement, but we don't have anything else preliminary.
Any preliminary matters that the state wishes to address?
No, Your Honor, I would agree with that recitation of our understanding.
Okay. Ms. Nichols-Cook or one of your co-counsel, if you're ready to proceed with your opening, you may do so.
Yes, Your Honor. Ms. Thompson is going to do the opening.
Ms. Thompson, whenever you're ready.
All right. No jury in this one. It's just the judge. Some water, Troy.
Your Honor, with the court's permission, I'll stand just for this opening portion of the proceedings today.
Certainly.
Also, Ellie Veldman.
Good morning, Your Honor. Todd Mullis has always believed that his wife, Amy Mullis's death was a tragic accident. He always believed this because he was on his family farm the day that she was injured. He was there right after his son, Tristan, found her. He was there as he and his son, Tristan, tried to give Ms. Mullis emergency aid and rushed her to where EMTs could get her to the hospital. He was there when first responders treated her injuries like they were the result of an accident. And he was not aware of any information that would tell him that what happened to her was anything other than an accident.
Sorry, the cops are
Even when police began an investigation and began to treat him like a suspect, he did not stop believing that what happened to Ms. Mullis was an accident. He knew he had nothing to do with her death, and he didn't believe that there was any evidence that anyone else did either. His account of what happened and his beliefs, unlike the accounts of some of the people that you're going to hear in this post-conviction trial during this week, has always been the same. But at trial, he did not have any way to present evidence to the jury that this was an accident. And that issue is what the court's going to hear about over the course of this hearing. The court's going to hear evidence that he begged his attorneys, begged them all through pretrial preparation to investigate this case as an accident. The court's going to hear evidence that his lawyers disregarded what he was telling them. The court's going to hear evidence that his lawyers did not talk to experts or fact witnesses that would have helped them understand and present a case that this was an accident. And the court's going to hear evidence that his lawyers did not listen to his explicit direction to investigate these issues and to pursue this case as an accident. And because his attorneys did not listen to him, because his attorneys did not investigate or present these issues, the jury did not hear important evidence that they needed to hear to understand that the state's case was simply wrong. The jury heard the exact opposite of what Todd Mullis asked his lawyers to present. They heard his own lawyer in opening statements tell the jury that Todd didn't know what he was talking about, that Ms. Mullis was murdered. They heard his own lawyer, in effect, tell the jury that Mr. Mullis was not credible. They heard his own lawyer make these concessions on day one, right when this trial began, and then really have no defense to present on Todd's behalf. His lawyers conceded guilt in this case without any plan to present another defense. The court is going to hear evidence that Todd didn't agree to this plan. He didn't know this was the plan. He'd actually asked his attorneys to do the opposite. And at this point in the proceedings, the court has heard in various pleadings at other hearings that we've had, the PCR team for Todd repeat this to you over and over again in all of the filings, that this was an accident, that this is what this case is about. And we've repeated that to the court because it's true. And it's among just the many reasons that Todd Mullis deserves a new trial and what this court is going to hear at this hearing. On behalf of Mr. Mullis and his team, we're grateful that after all this time that that Mr. Mullis is able to be in court this morning to remedy this wrong.
He's
Nobody
trying to get a new
Todd trial, but this week he'll have an opportunity to be heard through this case. And the court is going to hear other important evidence as well that the jury never heard that is going to create at least the reasonable probability that the outcome of his trial would have been different if the jury had heard everything that the court is going to hear over the course of this trial. The court also knows that this is the rare PCR case here in Iowa with an actual innocence claim. And that is what the court is going to believe and know about Todd after this hearing. The court also knows that all of Mr. Mullis's most important claims survived the summary judgment rulings that the court made, and that the court is going to hear his claims and his evidence this week. And everything that this court is going to hear is going to establish that the underlying trial that Todd had was nothing short of fundamentally unfair. It was unfair because of the actions that his trial counsel failed to take, that any reasonable attorney would have done on Todd's behalf. It was unfair because the state withheld from Todd important favorable evidence that would have undermined confidence in the outcome of this trial. And it was unfair because the trial prosecutors did things that resulted in misconduct in how they presented the case and what they presented. And the court's going to hear evidence that makes clear that Todd Mullis was right. As we said, the court will hear that Todd's attorneys conceded right at the beginning of this trial that this was a murder. And with that sort of tent pole in the state's case, the state killing the jury and nobody disagreeing that Ms. Mullis was murdered, that resulted in a situation where there was really no meaningful adversarial testing of any of the evidence that the state presented. And the court's going to hear evidence about each of these issues this week. The court is going to hear that the state then was allowed to present witnesses giving contradicted hearsay and innuendo that painted Todd in a bad light. The court's going to hear that that evidence painted a false image of Todd, of his marriage to Miss Mullis and his family, and that made random Google searches that were done by a family with a house full of teens and preteens seem like evidence that Todd was planning to harm his wife. The court's going to hear the truth about those searches this week. Without Dr. Cruz, the state's main witness, telling the jury that this was a murder, that evidence is what it is, which is kind of silly, meaningless, evidence that really doesn't explain to anyone what happened to Miss Mullis. The court's also going to hear from fact witnesses that have important details that help us understand what experts that the court is going to hear from this week are going to say, which is that Miss Mullis's death was an accident. The court will hear from first responders and from other people through depositions and through live testimony who witnessed medical efforts for Miss Mullis. The court's going to hear from those experts that I mentioned that are going to explain from a variety of disciplines how all of the objective evidence in this case demonstrates that Miss Mullis's death was an accident and that the testimony that Dr. Cruz told the jury in this case was just wrong. The court is going to hear, either live or through depositions, from Todd Mullis's trial counsel. And the court is going to learn about the mistakes that they made and that those mistakes were not about strategy. They were just mistakes, things that were just wrong and cannot be explained by any strategy. Witnesses? The court's going to hear from an expert, Sean Castle, who's going to explain that the family's Google search history and electronic data from their home is exactly what it appears to be. Google searches from a family, from teens, from preteens that are using Google to search for things, sometimes random things, as we would all expect teens to do. And the court is also going to hear from depositions, from documentary evidence that makes clear that anything that anyone testified to about at trial about Todd is going to be a product of them being told that their friend was murdered. And believing their friend to be murdered made statements that were hearsay, that were innuendo, that don't aid in understanding what happened to Miss Mullis at all. I want to say one final thing about the evidence that the court is going to hear during this trial. Mr. Mullis is here today because the state made the Mullis's private family tragedy public. And I say this because Mr. Mullis is here, his children are here, members of his family are here, and certainly for Todd and his family, they would have preferred that the investigation into Miss Mullis's case was private, and that their family's privacy was respected, and Miss Mullis's privacy was respected. If that had happened, and the authorities had made the right decisions in their investigation, then he would not have needed a public hearing like the one today to get the justice that he would deserve. And it is truly unfair to Mr. Mullis, to his children who are sitting here today in support of Todd and his innocence, to have this be the forum to discuss the issues in this case. And I say that because the court, over the course of this week, is going to hear scientific evidence that is going to be difficult for this court to think about and to hear and to see. And as Todd's attorneys, and on Todd's behalf, we're going to do the best we can in our presentation to respect Miss Mullis's privacy, to respect the tragedy of her death, but it's going to be difficult to do that in light of the evidence that we need to present, because Miss Mullis's private medical information is going to be the subject of this hearing, her privacy in terms of her body, her privacy in terms of the detail of her death and her medical history, those are going to be made public during this hearing. Her private life. Everyone has things that are appropriately private about their life that shouldn't be the subject of a public hearing, but we're going to have to present and hear about some of those things this week.
Is inspecting the wall.
And present them in a public way that Miss Mullis and the Mullis family don't deserve. This is not how Mr. Mullis would choose to have this resolved, but that said, because this is the evidence that the state relied on to charge him, because it's the evidence that was wrong, that was relied on to convict him, because his lawyer was ineffective in combating all of this evidence, all of the errors at trial that led to us to be here today, this public venue is the only way that Todd can achieve justice, and that's why he'll be presenting about these issues this week, because he does deserve a fair trial, a trial where the jury hears the truth about what happened, a truth that's grounded in science and that's grounded in what knowledgeable, experienced professionals have to say about what happened to Amy Mullis and what those knowledgeable professional experts concluded about the facts of this case. That's what this trial is going to be about, Your Honor. And at the end of this hearing, the court is going to agree that Todd's trial was undeniably unfair. If the state chooses to retry Todd after this hearing for what science tells us and will tell this court was simply not a homicide, then a jury deserves to hear the truth at a fair trial where everything is going to come out from knowledgeable, experienced people that will allow the jury to know the truth. And at the end of this hearing, Your Honor, the only just outcome will be to grant Todd Mullis a new trial. Thank you.
Thank you, Ms. Thompson. Counsel for the state, did you have an opening you wish to present?
Briefly, Your Honor. Thank you.
Whenever you're ready, Mr. Duden.
Thank you. Good morning. My name is Josh Duden, along with Thomas Bakke and Scott Brown. I represent the state of Iowa in this post-conviction relief proceeding.
They look pretty young.
As the court knows, Todd Mullis was convicted in September of 2019 for first-degree murder by a unanimous jury for causing the death of his wife, Amy Mullis. The Iowa Court of Appeals affirmed that conviction later on direct appeal. And here we are in a post-conviction relief proceeding which Mr. Mullis has brought and commenced to attack his conviction again. The evidence will show, and the evidence has in fact already shown, that Mr. Mullis took the stand at the underlying trial and agreed that Amy Mullis was murdered. He agreed on cross-examination that somebody took a corn rake and stabbed Amy Mullis in the back 2 or 3 times. He agreed on cross-examination that he actually knew this wasn't an accident. And yet we are here today to ensure justice and a fair trial occurred. The evidence will show that sufficient evidence still exists to support the murder conviction of Todd Mullis' murder conviction. The evidence was enough for the Court of Appeals to affirm it, and the evidence will be enough for the court to deny this post-conviction relief application in its entirety. Many claims are brought pending before the court right now, but the important evidence was presented at trial. And a shrapnel shot approach or a shot in the dark in a way is not a way to hit the mark here. The evidence will show certainly that expert testimony will not be enough to attack what the evidence actually showed at trial and what has already been upheld on appeal. And that's that Todd Mullis murdered his wife, Amy Mullis. And so at the end of this, the state will ask the court to deny his post-conviction relief application and let his conviction stand to ensure that a just trial had occurred already and find that his conviction of first-degree murder should stand. Thank you.
Thank you,
Short
counsel.
and sweet, straight to the point. Now on with the 40 witnesses. This is a trial. It is a post-conviction relief trial. I've updated the title to show that. Thank you very much, Scott's.
Are you ready to call your first witness?
Yes, Your Honor. The applicant would call Carrie Pierce.
Yeah, it's a pitchfork with a curve in it, a 90-degree bend. It's a
Your Honor,
honking.
Is the court's preference that exhibits be put on the screen for everybody and the witness to see?
Please.
We can do it that way if you have them on your computer.
We do.
Okay.
I know. I feel like you also have to allow or hit a special buttons.
I do. Let's see if we can get that rolling.
Let's see if we get to see. It looks like his son up there on the first row. It looks like that's him. HDMI cable has been handed to the proper bailiff to make the connection.
Go ahead and have a seat. Ms. Piercebacher, if you want to pull that screen up in front of you just a little bit, because that's where the exhibits will display for you.
Okay, thank you.
Okay. Can you see?
No jury present, so we can pretty much
and you can adjust
look all
that
around
so
the
that
corner.
it's not blocking you entirely.
Okay, thank you.
This is a trial for a hearing for a new trial.
All right, and I'll
Does that
swear
make
you
sense?
in. Okay. All right, you've been called as a witness. If you'd raise your hand, you've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
We've never seen one of these.
All right,
which
Ms. Nichols
I wanted
Cook,
to see.
whenever you're ready, and just for your benefit, when you identify an exhibit, it will be displayed on my screen and the witness's screen initially. once it's been admitted, then we can put it up on the big screen, assuming I initiate contact with all the right buttons. All right.
Thank you, Your Honor.
Okay, whenever you're ready.
Ms. Piersbacher, could you state your name for the record today and spell it for the court reporter?
Yes, my name is Carrie Piersbacher, K-A-R-I-P-I-E-R-S-C-H-B-A-C-H-E-R.
Thank you. We appreciate you being here today. Can you tell the court how you are employed?
Iowa.
I'm employed by Edgewood-Colesburg School District in Edgewood, Iowa as a music teacher. I'm currently the 512 band director is my current position.
And do you also volunteer in your community?
Yes, I do. I'm a volunteer fireman and EMT in Greeley and an EMT in Edgewood.
Okay, that's why.
And Greeley and Edgewood would both be towns or their own municipalities?
Yes, they are two separate towns here in Delaware County. They're closely located together, and I work in Edgewood, so we kind of run with both services, and both services do work closely together, so a lot of our calls are shared. If one gets called, a lot of times the other one will as well. Not always, but often.
And both Greeley and Edgewood, are they entirely volunteer organizations? Okay. And does Greeley run at the EMT level or at a different level?
We run at an EMT level. That means that we're guaranteed to have at least one EMT on the rig when the ambulance leaves and arrives at a patient.
What can an EMT do?
An EMT does basic life-saving support. We can do CPR, we can splint, we can do basic life-saving care. We cannot do anything invasive, such as in IV, and we cannot administer any drugs through IV or through injection. We can give basic drugs such as oxygen, aspirin, Narcan for a suspected drug overdose, and we can give albuterol for a breathing difficulty or an asthma attack.
Okay.
And those are the 4 drugs that we carry in Greeley that we are allowed to give.
What's the next higher level of care?
After EMT, then you would get to the paramedic level, and they can do those extra things. They can start IVs, they can administer drugs, and that would be the next level up. Edgewood runs at a paramedic level, and then I believe Manchester is a paramedic level, and then Colesburg and Earlville, I believe, are provisional Ps, which means that they sometimes have a paramedic on board, sometimes don't, depending on the availability of their paramedic in town.
And would you consider all of these agencies to be emergency responders or first responders?
Yes.
And how long have you been an EMT?
Getting close to 25 years now. I think it was 2000, 2001, around in there is when I took my classes and completed them. I believe I started them in fall of 2000 and completed in 2001.
And you mentioned that you had to take a class.
Yes.
What are the components of that class?
The class, I don't remember the exact hour amount, but there's so many hours of class time instruction. It lasted 5 or 6 months when I took the class. It began in late September, early October, and ran through March. We met 2 to 3 nights a week for 3 to 4 hours a night. Sorry. Yeah. So we
slow down.
2 to 3 nights a week. And then, so that was the classroom portion. And then as we were taking the classes, you had to pass the different units within the class. Once you passed the class, then you had to also do ride time and clinical time, so many hours working at a hospital ER, making patient contacts and practicing your skills there. And then also so many hours ride time, which would be with an ambulance service, again, making patient contacts and practicing in ambulance situations. Then once that was all done, then you were finally qualified to take the state test where you had to pass skills tests, and then if those were passed, then you went on to take the written test, and then if that's what was passed, you got your license.
Perfect. And then you could start.
And then you can start, yep.
And do you also like recertify or have continuing education?
Yes, we have to do the certifications just changed recently. Now the current level is it's 20 hours of recertification every 2 years for an EMT, but there are certain categories that have to be met. You have to do certain hours of cardiac, airway, trauma, etc. It used to be it was just a blanket 24 hours of recertification, any topic. Now they have different topic categories that you have to hit in order to recertify.
This woman's
Great.
amazing.
And
she must be an incredible music teacher, too, if she does this on the side.
Paramedic services like Manchester, are they also volunteer, or are they employed or full-time employees?
Most of the services in Delaware County are volunteer, except Manchester is a paid service. They are run out of the hospital, and that is their job, is to be on call in the ER and run with the ambulance.
And so as a volunteer, if you're not on a schedule or you're not being paid for certain hours, how are you notified when your assistance is needed?
We all carry pagers or radios. Greeley actually carries like radios similar to a walkie-talkie. That if it's set on page, you only get notified when your department is paged, or you can possibly open it up if you want to and listen to everything that's going on in the county, and then you would hear when other towns are getting paged as well. But then when that goes off, then we know that we have a call and we respond to the station.
And you also live here in Delaware County?
I do live in Delaware County.
And did you grow up here?
I did grow up in Delaware County as well.
This is fascinating.
Are you familiar then with the geographic area and the roads and where different landmarks are?
Yes.
I want to ask you specifically about a call that, and about November 10th, 2018.
Okay.
So she teaches music. Her pager goes off. She's like, kids, keep practicing your recorders. I've got to run,
Judge,
do EMT stuff.
Can we approach for a quick moment?
Sidebar. I'm going to count that as an objection because I think it was raised by the other side while she was doing her stuff, and now they're approaching. So there's our first one with an objection. Audio hiss is terrible. Let's see what I can do for that. It's white noise, so it's tough. I can turn it down a little bit, but should count the sidebars. So far, they're the same. One objection, one sidebar. Where have all the lawyers gone? Long time talking. No, we count the trains.
I've just been informed that there are individuals observing the trial who are taking photographs with their phones. That is not permissible.
Everybody delete them. Bailiffs, you're supposed to be on this.
Any phone in the courtroom is to be turned off and put away. If photography, videoing, or anything is observed by any non-approved individual, there are obviously members of the media who have been approved, but any other individual who is taking photos or recordings of any sort, if that is observed or it continues, you'll be asked to leave the courtroom. Thank you.
It's not a very stern warning. Should take their phone until the end of the case.
Yep, you may continue, Ms. Nichols-Cook. Ms. Pierschbacher, you're very fast.
Slow down.
And I don't blame you. Nobody wants to be the first witness.
Yeah.
So if you can slow down just a little bit.
I will try.
Okay, thank you. All right.
Ms. Pierschbacher, I believe we were getting ready to start talking about November 10th, 2018.
Yes.
Do you remember that day and what you were doing?
Yes. That morning, my husband and I had gone to Cedar Falls to pick up our 3 kids. They had a sleepover with their grandparents the night before. And then as we were coming back from Cedar Falls and traveling north on Highway 38, just about home, my husband did have his pager open, as I'd said, you could just listening to traffic, and we heard a call from Manchester ambulance to the Earlville area for what appeared to be a farming accident at that time.
And so when you say he had his pager open, are you saying that it was open to the entire Delaware County
yes,
traffic?
We could hear everything coming across. It's called County Fire. It's the channel that all the fire and EMS are paged on. We didn't necessarily hear what all law enforcement was saying or what anyone else in the county. It was the fire and the EMS paging channel is what he had open.
And you were with your husband, Dave?
Yes, Dave, my husband.
Same last name?
Same last name, yes. David Pierschbacher was his name.
Can you tell me a little bit about Dave and why he had a pager?
He was the fire chief in Greeley. He ran basically the fire side of our service, and at the time I was the EMS officers, which put me in charge of the EMS side of our service, but it was basically one combined service. So yes, we were both members of Greeley Fire and Ambulance. We both carry pagers. His happened to be open to the Delaware County channel at that point in time. Mine was closed to just page.
And do EMTs normally work together in twos or in pairs?
Our protocols is that you always go with at least two. You never leave the station without two. And since we are an EMT service, one of those two must be an EMT. We do have members of our service who are fire only. We have some people who are EMRs, which means emergency medical responders, which would be the next level below an EMT. There's a couple of skills that EMTs do that EMRs cannot. And we have a few of those. But our protocols are if the ambulance goes, there's a minimum of two people on board, and one of those two must be an EMT.
And was Dave an EMT?
He was as well, yes.
And it's my understanding he's unable to be here today.
No, he is not here today.
And why is that?
He passed away in 2022.
Okay. So while you were driving back from Cedar Falls, I think you started to say you were listening to traffic and you heard a call. Can you tell us about that call?
We heard it sounded like Manchester Ambulance getting paged for what at that time appeared to be a farming accident. It said that there was a male subject who was transporting a female subject to the hospital along 170th Street, that she had been hit by forks, and that that Manchester was paged out to intercept with them. But also at some point it was said that the original location was somewhere near Earlville, because I remember Dave asked me, why is Manchester responding to Earlville? And I said, I don't know.
Was that unusual?
Not kind of. Usually Earlville would have taken that area, but we didn't know, were they out on another call or something else? There are circumstances where different ambulances cover different territories.
And is Earlville also a volunteer?
They're also volunteer.
Okay. And did you have any impression or recollection of what the demeanor was while you were listening to this radio traffic from dispatch?
I just remember everything just seemed very confusing. We were just listening to the traffic, and we heard Manchester Ambulance go en route, and we heard them continue to ask dispatch for a location, and that they said that they were coming in on 170th Street, and then at some point we heard them say that the subject had stopped so that they could start CPR on the female victim, that they were somewhere along the road on 170th Street. So Manchester Ambulance headed in that direction. And so we were still continuing north on Highway 38 from Delaware to Greeley. And at some point, Manchester Ambulance was continuing to ask for more directions, or how far out are they, and they really weren't getting any information. And then Manchester Ambulance asked dispatch to page first responders, and that's when Dave and I said, oh, that's us, we need to get to the station, because we even flipped on our blue light, our light that we use to respond to situations, and we started heading right for the station, thinking that it was us getting paged and we had to get there. And then dispatch actually paged Manchester first responders. So we're like, oh, but we were already at the station at that point, so we just waited for a minute to see what would happen.
And for those of us that didn't grow up in Delaware County, how close is Manchester and Greeley, or along 170th Street?
Along 170th Street. 170th Street, it's also known as the Oneida Blacktop. It is a long road, I don't know, probably 12 miles, I'd say, between Greeley and Manchester-ish. I know it's 17 to my house, but I live a little bit further than Greeley, so.
At some point, while you and Dave were at the Greeley station, did you prepare to respond or leave the station?
At some point when we continued to hear the voice traffic back and forth of where are they located, how far out, Dave did get on the radio and ask Manchester Ambulance if he would like Greeley to respond from that side of 170th to see if we could find them, and figuring between Manchester and us coming from the two directions, eventually we would run into them at some point. And Manchester Ambulance responded yes. So Dave and I got in the ambulance and took off, and we radioed to Manchester that we were en route. We radioed to Manchester Dispatch that we were en route.
Okay. And so is it a fair characterization that the people needing help were somewhere on 170th Street. The Manchester Ambulance left from the hospital in Manchester, and then you left from Greeley.
Went from Greeley.
And you guys, did you eventually meet?
At some point we were going to meet up. We actually found the victim first. They ended up being very close to Greeley, actually. They had not gotten as close to Manchester as we had thought they had maybe gotten. We actually found them just south of Greeley, 2.5 miles, at kind of the intersection of 38 and 170th.
Great. What did you see when you got to that intersection?
When we got to the intersection, the first thing we noticed is the flashing lights from the deputies' cars. At that point, the deputies had arrived. We had just passed that location a few minutes before, but didn't notice anything. Now we saw the flashing lights, and so we're like, that's where it is, and we radioed to Manchester where we were. We went to turn into the driveway, and one deputy ran to the road to meet us to make sure that we saw them and that we knew that's where we were going. So we pulled into the driveway. It was a driveway of a home that was under construction at the time. So there was nobody who lived there, and the driveway was very rocky and muddy. It was under construction. And so when we pulled in, we could see a deputy was performing chest compressions on the female victim, and there was a forklift nearby for the construction of the home. And so after being paged that we had heard somebody hit by forks, I was still thinking bale spears from a tractor, and then I started to think, oh, that forklift was somehow involved in this incident. And so Dave and I pulled the ambulance over as we pulled into the driveway to the left to get out of the way for the other approaching ambulances. I went directly to the victim to relieve the deputy who was giving compressions, and Dave got the equipment out of the ambulance, the Lucas device and the AED.
Okay.
And then he met me at the victim a few seconds later.
And if I missed this, did you know who was building that house or whose property you were on?
I did know whose property we were on. It's the property of Brian and Rachel Krogman.
Okay. And you mentioned that from the radio traffic and from the dispatch statements that you thought you were going to a tractor baling fork accident.
That's what I thought.
For those of us that aren't farmers, a baling fork, a larger item?
It's a large attachment that goes on the front of a tractor to move large round bales.
Okay. And did you have any concerns about a patient being transported by their family towards the hospital?
No.
And why is that?
Because it's common in our area. We're very rural. We all know what the transport times are and what the response times are. I know just for our own department, our goal is from the time of the page to be at the patient within 10 minutes. And I think the community knows that too. So, and I know a lot of people kind of think, well, I can be at the hospital in 10 minutes. And so, no, it is not unusual for a family member to just take a loved one on their own, thinking that they could probably get there faster than waiting.
And in your 25 years of being an EMT, have you responded to other farming type of accidents?
Yes. It's not uncommon in the area. It happens. It's a farming community.
Round bales as opposed to rectangular
Circling
or square
back to
bales.
what you saw when you
It's just a
were
roll
in the
of hay
driveway,
instead of a box of hay.
can you describe the patient and what you did next?
As I approached the patient was lying on her back. One of the deputies was doing chest compressions. I observed she was wearing, it appeared to be heavy chore-type clothes, like a thick Carhartt coat. Underneath was a thick hooded sweatshirt.
Went through her coat?
I believe I said she was lying on her back on the gravel driveway. Her head was turned slightly to the right, and her face, the right side, was covered with blood and a brown substance that appeared to be vomit. And the vomit was coming from her nose and her mouth. It was on the right side of her face, and it was also caked in her hair.
Okay. And what was the first thing you did when you reached the patient?
I took over compressions for the deputy.
Why did you do that first?
Because 2 minutes is about the limit that anyone can do good chest compressions. It's just standard that you try to relieve a compressor within 2 minutes if possible, just because after that fatigue starts to set in and then the compressions aren't always as effective. I had no idea how long he had been doing compressions. I was guessing probably longer than 2 minutes at that point. So I was trying to relieve him and get a fresh person on her until we could get the other equipment in place.
And when you started chest compressions, were you doing them over the sweatshirt or over the coat?
The coat was open, but I continued to do compressions over the sweatshirt.
Okay. And did you observe any other obvious injuries or wounds?
No, not at that time.
It's durable work gear.
And did you were you expecting to see something else?
Well, I was picturing getting hit by bale forks. I was expecting to see very large wounds somewhere and that I was not seeing. And so I was confused as to how the bale forks came into this picture, because I wasn't seeing the massive trauma that I was expecting to see that I would expect bale forks to cause.
Bale fork is like a javelin.
And did you know who the deputies were at the scene?
One was Deputy Thompson and one was Deputy Holub.
Okay. Did you guys have a conversation or exchange information about what had happened?
We just started talking. I do know at one point when I started compressions and I asked what happened, one of the deputies told me, I think we were dealing with a fall. And then I'm pretty sure at one point I asked, did this happen here? Because I was still under the impression that that forklift I saw sitting off to the side had somehow been involved in this incident. And then that's when Todd, who was in the background, he said, no, this didn't happen here. This happened at our farm a few miles east of here.
Did you know the identity of your patient at the time?
At that point, no, I did not.
Okay. Did anybody else from the Greeley EMT team respond?
Eventually, there was a third Greeley person who got to the scene of the patient, Steve Engelken. As I took over compressions, I did ask the deputy to page Greeley for more help, because at that point our pagers had not tripped yet. It was just Dave and I. I knew we had other people close by that we could probably get there faster even than Manchester ambulance could, if they would just be paged. And the deputy asked for Greeley to be paged, and the dispatch replied with, Greeley's already on scene, they don't need to be paged. And so we asked again to have them paged for more help, and then Greeley was paged. By the time most of the responders responded, Manchester had already gotten there. So Steve Engelken is another member of our service who did get to the patient. I believe he got there at roughly the same time that Manchester ambulance arrived. Okay. But I know he was helping with resuscitation efforts at some point. The rest of the Greeley people arrived, but already saw Manchester ambulance and Greeley ambulance and everyone there, so they stayed on the road and conducted traffic control and did not approach the scene.
Okay. And then you mentioned that Dave got the Lucas device and the AED off the ambulance. Can you tell us a little bit about what a Lucas device is?
A Lucas device is basically an automatic CPR device. There's a board that resembles, I don't know, maybe a snowboard would be the closest comparison I can think of. Has a slight curve to it. It goes under the patient's back, like from armpit to armpit, and then there's another U-shaped device that comes down and clips over top of that, and then from that device there's a plunger that goes down onto the patient's chest, and then once it's turned on, the plunger does the compressions for you, so then the manual compressions are no longer an issue and we don't have to worry about rescue or fatigue. The Lucas just keeps going with good quality compressions.
Okay. And so, and then what is how is an AED different?
The AED is an automatic external defibrillator. That is the part that actually attaches to the person's chest and shocks the heart to try to get it back into rhythm.
Okay. And what did you do? What did you guys do first?
Once Dave got to us with both of those devices, the first thing we did is attach the AED. At that point, we pulled the victim's sweatshirt up and we attached the two pads. The pads go upper right, lower, and then on the right side, and then on the rib, lower rib on the left side. So we attached the pads, we turned it on, it analyzed, and then an AED is looking for a certain cardiac rhythm before it will issue a shock. So as it analyzed, we stopped our compressions and let it analyze, which is protocol. And then the first time it analyzed, it said no shock advised, which meant it did not pick up that shockable rhythm. Continue CPR, so we continued CPR.
Okay. And when you pushed your patient's clothing up, did you make any observations about other injuries?
Yeah, we looked, as we lifted up her shirt, we were looking for some other things to see because I was still trying to figure out how this injury happened. There was what appeared to be possibly a slight bruise on the right rib cage. At that point, it was very faint. We thought maybe it was a bruise, but we weren't 100% sure. And then there was also a mark above her right breast that looked possibly like a very small puncture wound, but again, we weren't 100% sure what we were looking at. We saw something there, but were not able to determine what had caused that. So we made note of it in our report.
Did you
I'm trying to
observe
imagine this
anything,
woman teaching me how to read music as well.
Any injuries on her face area?
Again, possibly a slight bruise on the right side that was noted in the report. Again, at the time that we saw her, it appeared very faint. We thought it was possibly a bruise, but we were not 100% sure. So again, we noted it in the report.
Okay.
Great
After
witness.
you set up the AED, did you then do the Lucas device?
Yes, once we did the first analyzing with the AED and said no shock advised, continue CPR. I continued manual chest compressions, and then Dave and the deputy started setting up the Lucas device. Dave started and the deputy assisted with getting everything in place. I continued manual compressions until the Lucas was in place and could start.
Okay. And you were able to utilize the Lucas to do chest compressions?
Yes, and then once it was in place, we turned it on and the Lucas took over chest compressions.
What did you do after that?
Then I went back to the ambulance to get the airway bag to secure an airway and to start breathing for the patient. So I brought the airway bag back to the patient, opened it up. I took out a King LT, that was the intubation device preferred at the time, and so that's what I took out. At the time that I had gotten that out, then that's when Manchester arrived on scene.
Okay.
I apologize for the interruption, but could we have a quick sidebar?
Sure.
Okay. Can we have a quick sidebar? The judge is stepping down for the sidebar. While this goes on, we read this morning, we're going to keep listening to the sidebar. We read this morning a filing by the defendant asking for a new case, but they didn't get it. They didn't get the new case. They're like, there's nothing wrong. So I don't know what happened between that filing and right here where we got a judge hearing these arguments. This is a post-conviction relief hearing, and I'm not sure if just Iowa does things a little differently here. He didn't win his appeal, from what I can see. The appeal was like, no, everything's fine, everything's good, there's no problems. So yeah, when we hear a train whistle, we're gonna add to the train the toot tracker. Should we call it a toot tracker? Would that be all right? So the defendant is wearing orange in court today because he has been convicted. As he sits there right now, which you can't see him right now, but as he sits there, he is guilty. He's been found guilty by a jury, and he is currently serving his sentence. New evidence might help. His sentence, I'll have to look. I thought it was life. Somebody remind me. I don't remember. He was convicted I think it was 4 or 5 years ago. Life sentence. Thank you, Josh. It is life. I think they're suing the state according to... Okay, so here's the weird thing. This is described as a civil trial in a criminal case. So this might be Iowa specific. I don't understand the intricacies of why we got to this point. There is no jury, so this is a bench trial. If they're suing the state, because the appeal was denied. It's weird. Who has the farm now? I don't know. I wonder if it's family. Look at the great woodwork. Great woodwork there. Mullins v. Iowa. Farms in a family trust. That's the way you should do it. The corn rake. I showed you guys the corn rake a little earlier. Hold on just one second. Let's pull it back up here for you. This specific corn rake. This is a photo from the first trial. So the corn rake being held right there is the one that was found at the scene. It looks like a pitchfork that's just been bent at a 90-degree angle. That's the best way to describe it. So if you've seen a pitchfork, that'll give you an idea of the sharpness of the tongs, the strength, and everything. It's just meant for, jabbing it down into, some sort of agricultural product and then pulling it. Corn cobs, things like that. So this could be used for pigs.
Go ahead and continue without me.
I'm going to step out, continue without me, says the prosecutor.
Folks, I want to be crystal clear that unless you are an approved member of the media, there is to be no photography, recording, social media posting,
no socials,
or any recording of any kind of this proceeding. I am aware that there is a specific individual in this courtroom who has posted photos on a social media site from this trial this morning. It is only because I cannot ascertain specifically if that photo or those photos were posted before or after my preliminary warning that individual is not already being removed from the courtroom by a deputy. If there are any further posts, the individual will be removed, as will any others.
I'm looking for these posts, which are probably being deleted right now.
We will not have this proceeding derailed by members of the public who are not following the restrictions on recording, photography, and the rules of this court. My apologies to the witness and to counsel. I hope we have no further interruptions. Ms. Pierschbacher, again, if you can try to slow down. I think you just get faster and faster. Okay. All right. Ms. Nichols-Cook, whenever you're ready.
Thank you, Your Honor. Ms. Pierschbacher, maybe act like we're high schoolers, I guess, and we don't listen the first time and just go slow for us. But we were talking about an airway bag, and could you help us all understand a little bit about what you were using? I think we've all seen mouth to mouth, and so tell me about the airway bag.
Okay, so our airway bag specifically carries all of the equipment that we would need if a patient were to have a breathing problem. There is an oxygen tank in that airway bag. There is also it's called an AMVU bag. It's the bag that you put over their mouth and squeeze to help ventilate them. That we carry in there. There is also nasopharyngeal airways, which go into the patient's nose, and oral airways, which are hard airways that go into the patient's mouth that are used to hold the tongue out of the way. Those airways are used for a patient who is still semi-conscious and would have a gag reflex, who would not tolerate anything down their throat. In this particular case, we used a King LT, which is a long tube that is inserted into the patient's mouth, and it goes into their trachea, and there are 2 balloons that blow up to hold it into place, and then there's a small opening at the top that AMVU bag I was talking about. If you take the mouthpiece off, the round tip goes right onto the top of the King airway, and then we can ventilate directly into the patient's lungs. So that is what I was getting, the airway bag, and that's what we had decided was our best option for that patient at that time.
Okay. And was your patient responsive at all?
No.
Okay. And in order to insert the tube then into your patient, did you have to do anything with her mouth or her nose?
Yes. So when I inserted the tube, what I did is I positioned myself at her head so that she was directly in front of me. I was at the top of her head. Other people were still working on doing things with her. I was kneeling on the ground above her head, and then what I do to insert is I reach through and I grab her lower jaw and her tongue, and I lift it up to pull the tongue out of the way and to open her mouth. And then with my other hand, I take the tube and insert it into her airway, and then we have a syringe that then blows up those balloons to hold that tube into place.
That's how I pick up bass.
Earlier you mentioned that the right side of your patient's face had blood or maybe a vomit substance.
Yes.
Was that still present when you were inserting the tube?
It was still present, and before the tube was inserted, we used a suction device to suction her mouth clean and clear so that we could get the tube in without getting any extra debris into her airway.
Okay. Would getting debris in her airway be harmful to your efforts to get her breathing?
Well, it could, because then it would be basically like aspirating whatever that was, and then it would just cause further problems for the patient down the road.
Okay. And I think you mentioned that as you were working to do this, the Manchester paramedics arrived.
Yes, the Manchester crew arrived because at first when they arrived, we filled them in on the situation and told them what we had done so far and what we knew. And then I actually backed off on the airway for a moment, just because at that time it was their scene to control. And I just said, we're about to insert an airway. And then that's when they said, well, you are an EMT, you can do that skill, right? And I said, yes, I can. And then they said, please do help us. And so we stayed on scene and continued to help them as they were doing what they were doing.
And in addition to suctioning out the mouth and the nose, did you also have to move her face or handle, wipe things off of her?
I don't remember if we did any wiping. I do know we did have to suction, and then her head was turned slightly to the right, so we would have pulled her head back to center to make it easier to insert that tube.
Okay. After you inserted the airway tube, what do you remember doing next?
At that point, then we hooked up the airway bag, and I started to ventilate for her. The ventilations were going in harder than I expected them to. I was feeling some resistance, which is not normal. But at that time, that's when we were getting ready to move the patient. They had brought a sheet from one of the ambulances, and so the way that we lifted her that day is we did something called a log roll, where we roll the patient onto her side, put the sheet under her, pull it back out from the other side, and now she's laying on a sheet instead of on the bare ground, and then we're able to use that sheet to lift her and get her onto the cot and into the ambulance. So the sheet was the method that we used that day to get her up onto the cot and loaded. So at the time I got the airway in place was the time that we rolled her, got her onto the sheet, and moved her towards the ambulance. I was ventilating the whole way to the ambulance. When we got to the ambulance, I did tell the paramedic, please check this airway. There's more resistance than there should be. Make sure I got it right. And then I handed the airway bag off to one of the Manchester personnel, and they continued care to Manchester.
Did you know any other injuries during that log roll procedure?
During the log roll procedure, I did not see any other injuries myself. As the patient was rolled, I moved with her face to continue to give ventilations. I did hear one of the Manchester responders say, we have a through and through, when they saw her back. I personally never saw her back at the scene. I don't know what it looked like, but I did hear one of the Manchester responders make that comment.
Did you know any other injuries to her mouth, a cut, or anything like that?
No.
And in your experience, is the act of performing CPR or using a Lucas device a traumatic event to the body?
It can be, yes.
Was your care ending then as the patient was loaded into Manchester's ambulance?
Yes, that is where our care of the patient ended. We handed off to Manchester. Shortly after Manchester ambulance arrived on scene, so did Manchester first responders, because they were paged out after. So between those two crews, they got enough people in the back of the ambulance to continue care all the way to Manchester. So it was Manchester's full ambulance crew, and then I believe a couple of their first responders who came out in the first responder rig also went back with them to be extra hands to help with resuscitation. So we were not needed to go in the ambulance with them. They had enough people.
Okay. And at some point, do you learn the patient's name?
Yes, as we were loading her into the ambulance, one of the Manchester responders or ambulance members said, we need a name and a birth date for the victim. And then that's when we asked, what is her name and birth date? And that's when we learned it was Amy Mullis. Up until that point, I didn't realize who we were working on.
Had you met Amy Mullis before November 10th, 2018?
Yeah, we were acquaintances. Amy's and Todd's daughter was in gymnastics with my daughter, so we would see each other at gymnastics events, and they also attended the same church as us.
Did you realize the individual providing information to you during your care was Todd Mullis?
I did not realize that either at the time. It was out of context. I was used to seeing him together with the family, and this was out of context. So no, I did not place that. That was Todd as well.
Can you describe Todd's demeanor while you were on the scene?
From what I observed, he seemed to be kind of anxious, nervous. He seemed to be pacing in the background. He wasn't interfering with resuscitation efforts at all, but he was close by to provide information as we would need it. As if we would start to talk about something or ask something, he would respond right away with information he had or knew. But yeah, he was close by enough to give information, was pacing.
Nothing that alarmed you?
No.
I'm sorry, start over. Did you also then know Todd and Amy's children?
I did. At that point in time, I knew the younger two children better. Wyatt and Taylor went to church with us. I was their Sunday school teacher for a while. I knew Tristan also at that point from seeing him in church with the family, but I did not know him as well as I knew the younger two.
Did you see Tristan on November 10th, 2018?
Yes, a little bit later. Up until that point, I had not noticed him. After Amy was loaded into the ambulance and Manchester took off for the hospital, we turned to start getting our stuff picked up, and that's when I realized Tristan was there as well. He was standing back a lot further than Todd. There was a trailer attached to the pickup that they had been using to try to get Amy to the hospital, and he was on the back side of the trailer.
Okay. After the Manchester ambulance left, what did you and the other Greeley EMTs do?
Sunday school teacher.
Because some of the Manchester first responders had left in the ambulance service, or in the Manchester ambulance, that left a couple of their first responder vehicles unmanned. So our other responder, Steve, who was on scene, he actually helped Manchester to get the rest of their vehicles back to their station. Dave and I took the ambulance and we followed to Manchester because our Lucas device was still being used in resuscitation efforts. And so we said we would just follow and wait for it to be done to get it back. So we proceeded to Manchester. We stopped at the fire station we stopped at Manchester Fire Station to pick our other responder, Steve, up, because that's where they keep their first responder vehicles after he helped them drop those off. And then the three of us proceeded to the hospital to wait for the Lucas.
Okay. When you got to the hospital, where did you go?
We just went into the common area in the ER, the hallways. We were just planning to hang out in a corner and try to stay out of the way until things were done.
And did you observe Todd Mullis or any of the other family there as well?
Todd, I believe, was there and had a friend with him, and they were in kind of the family waiting room. They had a special waiting room, not the general public waiting room that everyone goes into. There's a separate one back in the ER for family to wait in, and so he was in there with a friend.
Okay. Did medical staff approach you and Dave or Steve?
One of the RNs came up to us as soon as we got there, and
calls for hearsay.
What did you and Dave do after you interacted with medical staff?
We waited. Dave we would take turns waiting in the family room with Todd. Dave spent most of the time in there. I went in, I believe, once for a couple of minutes.
Right here. And were you asked to go in? Were you instructed or informed that you needed to go into the waiting room?
Objection. Calls for hearsay or relies on hearsay testimony.
Your Honor, it's been offered to show what she did and why she did it.
Overruled. The witness can answer.
We were told to make sure Todd was not left alone and to make sure one of us was with him at all times.
Hearsay again. Ask that the objection precede the response, Your Honor.
Overruled. The answer will remain in the record.
In your 20 plus years of experience as an EMT, has that ever happened to you before?
No.
Did you make any observations of Todd's demeanor while you were in the waiting room or at the hospital?
It was similar to on scene. He appeared anxious to me, was pacing.
At some point, were you able to not stay in the family waiting room any longer?
Another RN came in.
Are you familiar with former Sheriff LeClaire?
I am.
Did you see him at the hospital on November 10th?
I did.
Did you speak with him or see him speak to anybody?
I did not.
Calls for hearsay response again, Your Honor.
I didn't ask what was said, Your Honor.
I did not speak to him myself. I did observe he and Dave speaking to each other.
And since Dave was a fire chief in the county, was that unusual or alarming?
No.
Okay. At some point, were you able to retrieve your equipment and depart Manchester Hospital?
Yes. At some point when the Lucas device was finished being used, we got it back, and then we left and returned to Greeley's fire station.
Okay. Did you respond to any other EMS calls that day?
We did have another EMS call later that night.
Okay. Did that take you back to Regional Medical Center in Manchester?
Yes, we transported that patient there as well.
Did you ever learn that there was concerns or instructions to complete your report in a certain way?
When we returned back for that second EMS call that night, we were actually with Edgewood crew at that time. Edgewood was the transporting service. They needed extra help, so Dave and I both ended up being in the back with the patient on the way in. When we got to the hospital, I stayed in the rig and started cleaning everything up. Dave and the rest of the Edgewood crew members actually delivered the patient into the ER. When Dave returned to the ambulance after dropping the patient off, he told me that...
Your Honor, hearsay within hearsay.
Nested hearsay.
Sustained.
Let me try to rephrase a little bit there. Did you complete a report about the service call regarding Amy Mullis?
I did.
And did your husband, Dave Piersbacher, contribute to that report?
He did.
Did your colleague, Steve Ingleton, also contribute?
He did.
Okay. And
6-volt welcome.
Did you
Thank
have
so
an
much.
understanding that you need to take some extra care or caution when writing your report?
Yeah, most reports are completed thoroughly, though I usually I always make a point that every report is completed thoroughly.
And at some point, did you learn that Amy's death was being investigated as a murder?
I did.
Okay. And do you recall when you learned that?
That evening at the ER.
Okay. I've got a copy of your report here marked as Exhibit 216. If we can show that to you to make sure we have the right report. We'll try to get it on the screen there for you.
I'm working on the audio from the 911 call. It might take a minute.
Ms. Pure-Clark, have you had an opportunity to look at Exhibit 216?
Yes.
Okay. And does this appear to be the report that you wrote and submitted regarding?
It appears to be.
And can you tell the date that you submitted this report?
I'm not sure it's on this front page, but if I remember correctly, it was November 13th.
And so that would have been just a couple of days after you responded to the call? And I think you just said you submitted it. Can you tell us a little bit about what that means? Like, how do you submit it? Where does it go?
The system that we use for EMS reporting is called Image Trend. We all go in and it's what every EMS service uses. We complete the report and then it stays open, and when we are satisfied that it is done, we hit lock and submit, and it is locked and submitted, and then it uploads to the state database, and at that point then it is considered submitted. Okay.
And after you submitted your report here in Exhibit 216, did law enforcement ever talk to you about your observations from November 10th or your report?
No.
Did anybody from the Delaware County Attorney's Office talk to you about it?
No.
And I apologize, I said law enforcement earlier, specifically Delaware County Sheriff. Did anyone talk to you? The Iowa DCI?
No.
And have you ever spoken to anybody from the Iowa Attorney General's office about the substance of your report?
No.
And were you aware, or are you aware now, that Todd Mullis was charged with Amy's murder and tried and convicted of that?
Yes, I am aware of that.
And then we'll flip to Exhibit 215 and have you identify that for us.
Yeah, this is an affidavit.
So 215 is an affidavit that you signed regarding November 10th?
Yes.
And my copy is a little faint, so maybe yours is a little better, but is it dated in 2023?
I believe so. I don't see the signature page on my screen, but I believe that's when it was.
We'll scroll for you.
Yes, 2023.
And prior to this affidavit in 2023, did you speak with any attorney representing Mr. Mullis?
No.
Any private investigators or anybody talk to you?
No.
Was there anything about Todd's behavior or demeanor on November 10th that was alarming to you or caused you concern?
No.
Your Honor, if I could have one moment, and then I think we already have an agreement to admit 215 and 216, but I would formally move to admit those exhibits. Got one or two more. I apologize. Thank you for your patience. Ms. Piercebacher, while you were on the scene that day providing care and waiting at the hospital, did you ever observe any or hear anything that caused you to think that Ms. Mullis's injuries were not an accident?
No.
Okay. And I know you said earlier that it's not uncommon for there to be farming accidents, and so can you expand a little bit on that, like what types of accidents you have responded to over the years?
Your Honor, I am going to object on the grounds of beyond the scope of the lay witness's testimony. She's not a certified expert, and it's her testimony as to other incidents are irrelevant for her insight and for purposes of this proceeding.
Sustained. Let me re-ask that. Have you responded personally as an EMT to other farming accidents?
Yes.
And have those included things like falls?
Yes.
And onto whether it's a farm implement or a fork or some other tool?
Objection, Your Honor. Again, this is irrelevant. It's both beyond the scope, not an expert, and simultaneously leading.
Your Honor, I'm asking for her personal experience. I'm not asking for an expert opinion.
Yes, we have been called to emergencies that involved farm implement, and we have been called to emergencies where people have fallen. We've been called to emergencies where people have been trapped. Yeah, there's several different types of farming emergencies that happen.
Okay. One last question is, do you have any recollection of the weather on November 10th? You know, it's winter in Iowa, but other than that, do you have anything?
It was very cold. I remember it was very cold, very bitter. I believe there was like a skiff of snow on the ground at the time.
Okay. Nothing further from me, Your Honor.
Counsel, any objection to Exhibits 216 and 215?
Your Honor, no objection to the inclusion of 216, but we would object to the inclusion of Exhibit 215, as it is hearsay, includes hearsay within hearsay as well, and is inadmissible. I believe it also predates the filing of this case and therefore was not made as a part of the record for any sort of consistency.
Another hearsay inception.
216 is admitted. Counsel, did you want to respond to the objections 215?
Yes, Your Honor. I think there might be some confusion. I guess it was my impression the state didn't have any objections to 215, but additionally, it's a part of the original post-conviction relief application filing in this matter. Ms. Piersbacher has identified it, and I can ask her some additional questions as far as, where the information comes from in it. But I do believe it's an admissible document that this court should consider.
Well, to the extent it was identified as an attachment, I guess, to the petition, it's there. The court will consider it in that fashion. Generally, I'm not going to admit affidavits, though, of witnesses who are here to testify. So 215 is not going to be admitted as a separate exhibit. Cross-examination.
Yes, Your Honor. Good morning, Ms. Piersbacher.
Good morning.
At the time of Ms. Mullis's death, you had been an EMT or volunteer firefighter for about 20 years. Is that fair to say?
Just shy of that, yes.
And since then, obviously, you are still a volunteer.
Correct.
On the day in question, you were dispatched around 11 minutes after noon, right?
Yes.
And you arrived somewhere around 12:14, 3 minutes later.
Yes.
According to your report, which has now been admitted as Exhibit 216, you reached Ms. Mullis, or Amy Mullis, for an assessment at 12:15, right?
I believe if that's what it says in the report, then yes.
And the Lucas device that you explained earlier was placed a minute later.
Yes, if that's what it says.
And at that time, you left Ms. Mullis's body, ceased compressions, and went back to the ambulance, right?
I did, because compressions were being taken over by the Lucas device.
So you didn't visualize her during that period of time?
I did not.
And you didn't administer the AED shock at 12:17 either, did you?
Whoever was running the AED did at that point. That's the time that it was shocked.
And I believe if we turn to directing your attention to what is page 4 of Exhibit 216, I believe it references that David Piersbacher was the one who placed that AED shock, right?
That is possible. Yeah, I don't have that page in front of me, but if that's what it says, then that's what happened.
And 1 minute later, Manchester Ambulance took over the care of and administered the life-saving efforts for Ms. Mullis, right?
Yes, once they arrived, yes.
So the entirety of your interaction spanned about 3 minutes?
Probably, yes.
And for the portion of those 3 minutes, you weren't actually with Ms. Mullis the whole time, were you?
Not the entire time, no.
And according to your report, as has already been admitted, you didn't see the injuries in question, right?
I did not.
And you didn't observe the full extent of any puncture wounds, right?
I did not.
You don't document any direct references to Todd Mullis in your report, do you?
No.
You never once reference Tristan Mullis in your report, right?
Correct.
And you were familiar with them, as you mentioned, right?
Mm-hmm.
Because your focus was actually on Amy Mullis and preventing her or administering life-saving care.
Correct.
So what we do know from your report is that you'd agree that she had bruising documented to her face.
Yes.
And you didn't actually note anything about her hands in question, correct?
No.
Why is he going after this witness so hard?
In fact, based upon your examination, you had no reason to check her hands. Fair?
We did not.
So you can't say whether or not she had any injuries to her hands, right?
That is correct.
Nor could you say that she has any injuries to her legs or feet, right?
No. Those, that was removed by Manchester ambulance. They cut the rest of her clothing off of her when they took over care, so that's why that is not in my report, because that was under their care.
So directing to your specific interactions with Amy Mullis on this day, you administered manual compressions.
I did.
And you placed the King airway device, right?
I did.
Tube. How long or how many tubes have you placed, would you say?
Over the years.
Can we get a little, objection, a little foundation as to like a time period? Are you talking the entire 20 years or?
Sure. In a general sense, without holding you to any specific number, over your 20 years time at that point, how many airway devices had you placed? How many tubes?
At that point, well, those were relatively new at the time. I mean, we haven't had those in the entire 20 years that I had been in EMT, but I have placed a dozen.
So you were fairly experienced or aware of how to place them?
Yes.
And to be fair, those don't come into contact with a patient's lips or anything like that specifically, right?
No, mostly it's my hand that comes in contact with her face or her lips as I'm moving her face out of the way to put the tube in.
And in this instance, Manchester ambulance is the one who was doing the suctioning, not you,
yes,
right?
Yes, that is correct.
So you weren't applying any force with an outside suction, right?
No.
Eliminate the chance
and
that she
do you
caused
recall
bruising.
or have any reason to believe you caused an injury to her lips yourself?
No.
And generally, when you place a King airway tube specifically, do you cause injuries to the patients you place them or administer them to?
I have not heard of that.
And in your instance, that hasn't happened, right?
No, not that I'm aware of.
So you don't have any reason to believe that she would have caused any damage to Amy Mullis's face or mouth or otherwise, right?
No.
And you didn't ride with her to the hospital either, did you?
I did not.
So your care or interactions with Amy Mullis ended at 12:18 or so?
Yes. Whatever time she was loaded in the ambulance, that's when my interaction with her stopped.
And so your total interaction with Amy Mullis would have been 3 minutes, right?
Probably, yes.
In your report, you don't call it a farming accident, though, do you?
What did I reference it as? What did I put in my narrative?
I believe when you were dispatched, and you can correct me if I'm wrong, that, like you said earlier, you believed that a woman had been hit by forks, right?
Yes, that's what it was dispatched as.
You don't mention a forklift, though, do you?
No.
And you don't mention any bale spears, right?
Nope.
So overall, you had no reason to believe or any reason to look into the cause of Miss Mullis's injuries, did you?
Just to ask what had happened, and again was told we weren't sure. We thought we were maybe dealing with a fall, was the answer that we got on scene.
Is it safe to say that the family members who are noted in your report, that would be Todd Mullis?
Yes. I believe I just referenced family members in general, correct?
Correct.
Yeah.
So in that sense, it would have been reported as an unknown incident to you, right?
Yes.
So it wasn't referenced as an accident by Mr. Mullis. Fair?
No.
I'm going to object at that point as asked and answered and beyond this witness's testimony.
Overruled. The answer will remain in the record.
That was you? Yes?
Sorry, could you please re-ask the question?
So Mr. Mullis had never referred to it as an accident or otherwise to you, right?
No. It was very confusing. We were trying to figure out what had happened. As you said, the 3 minutes that I was with her, we were trying to see if we could resuscitate her. So that was our primary cause. In my mind, I was running over what could have happened, but our primary focus was to get her back, get a heartbeat and breathing.
So your job wasn't to look into what caused the incident in question?
We asked the questions to help us figure out what we're dealing with. But in this case, it was very confusing. Nobody really knew. So we focused just on what we could see and took care of that.
So we've referenced your report extensively, which has now been admitted as Exhibit 216. Who do you submit that report to?
I believe it goes to the Iowa Department of Health.
So it doesn't go to any specific agency for inclusion, right?
No, it gets uploaded to the state.
And I believe you've previously referenced the National Emergency Medical Services Information System. Mm-hmm. Fair?
Yes.
Is that also called NMSIS?
Yes.
And for NMSIS, do you know who that goes to?
I do not.
So is it safe to say that you've never in your 25 years checked into where that goes, right?
No. I do know that when our service gets inspected every 3 years by the state, the Iowa Department of Public Health comes out and they do have access to all of those reports, and they have all of our information on when reports were filed and in what a timely manner, and that is checked into them. So I do know that at that point, the Iowa Department of Public Health Emergency Services Agency, who keeps track of the EMS services, they have those reports.
And so those reports don't actually go to anyone other than the state agency designated to receive them, right?
As far as I know.
And in that case, the NMSIS program is actually administered at the federal level, fair?
I believe so.
So that data is not being aggregated by, say, the hospital in Delaware County?
I don't know.
You have never provided the report specifically to a hospital in Delaware County, right?
Not that final report, no.
Did you provide any other version of a report to a healthcare provider in this case?
Yes.
And so that would be documented in the medical records or referenced otherwise?
It should be in Manchester's report that they received ours. What we usually do is when we get on scene, we don't pull out our computers and do the final report there. We have handwritten notes and we pull off the top sheet and it goes with the patient. So in this case, when we handed off the patient to Manchester, our top sheet of notes went with her, with Manchester, to become part of their report.
And that's because it was Manchester who was in charge of her transport to the hospital?
Because they transported her, yes.
And in charge of handing over care to the hospital emergency room?
Correct.
So that wasn't you in this
We
case?
did not hand her over to the emergency room. No, we did not. We handed her over to Manchester Ambulance Service.
But on scene, you talked to Todd Mullis, correct?
Yes. Well, in passing, he was in the background giving answers. I did not specifically talk to him one-on-one.
You also confirmed some of the details with the deputies, yes?
Yes.
And so in question, you were also known to the Mullis family, weren't you?
I believe so. Somewhat more so Amy and the younger two kids at that point in time.
Because you went to the same church and your families interacted,
Yeah.
right?
Yes.
So at that point, Todd Mullis and you were already familiar?
In passing, as an acquaintance.
Ultimately, it's safe to say you can't actually explain the full extent of Amy Mullis's injuries that she sustained that day, right?
No, I cannot.
And you can't describe the extent of the location of where her injuries were seen?
No.
And your report would only document the injuries that would already be noted in her medical records or by other care staff, right?
Objection. Beyond the scope of this witness's knowledge.
This judge only overrules.
There's been no foundation laid that she's ever seen medical records from a hospital related to Ms. Mullis.
Well,
Kelly, can you read me the question? I'm sorry.
I wasn't paying attention.
Your report would only document the injuries that would already be noted in their medical records or by other care staff, right?
I'm not sure I understand the question.
I'm happy to rephrase, Your Honor.
Right, thank you.
You mentioned earlier that the extent of the injuries would have gone to Manchester Ambulance, right?
Correct.
And that Manchester Ambulance would have provided that information also to the hospital, correct?
Yes, they should have. Yes, I assume they did.
And that's because they ultimately transferred care to the emergency room, right?
Correct.
So the bruising on Amy Mullis's face or the puncture wounds to her body or any other documented injuries would primarily be noted by her medical records or by that staff. Is that fair?
Possibly.
Because you would have provided or noted the same injuries that were noted by Manchester Ambulance, right?
No, objection, Your Honor. I think the question is asking this witness to say what Manchester paramedics did or what's in the Manchester reports, which she has not seen or nor did she write. So this is an improper question and asks for speculation.
Sustained.
After you responded for those and provided those 3 minutes or so of care. Did you have any other interaction with Amy Mullis?
No.
You did not provide the report to any law enforcement, correct?
No.
And you normally would not provide those reports to law enforcement,
Not
right?
unless asked.
I don't have anything further, Your Honor.
He sure said that
Any
nicely.
redirect?
Very briefly, Your Honor. Ms. Pierce-Bacher, law enforcement knew you were on the scene.
Correct.
You have been a member of the Delaware County community your entire life.
Correct.
Law enforcement spoke with you while you were providing care.
Yes.
Is it a normal protocol and or is it required by the Department of Public Health that you complete and submit a report?
Yes.
Do you have any obligation to send that report out to the law enforcement you interacted with?
No.
And you mentioned that you would have taken the top sheet of your notes and sent them with the patient. When you describe that, are you describing like a carbon copy where you also kept a copy of those notes? And we talked a little bit earlier about you submitted this report, but it included observations and actions of the other two EMTs from Greeley.
Yes.
Okay. And is that normal protocol for an EMS EMT report?
Yes.
And you were asked about your entire interaction with Ms. Mullis only being about 3 minutes. Is that unusual?
No.
You were asked a little bit about the dispatch and the farming records, and I believe you testified, so I just want to clarify that you heard over your pager, over the radio, and dispatch was calling it a tractor, baling, fork type of accident.
Yes.
Okay. And you and Dave responded from Greeley in part because Manchester was not responding fast enough or could not find the patient. Is that your understanding?
Yes, there was confusion on where exactly the patient was located and how long it would take Manchester to reach them.
Ms. Pierce-Bacher, you heard us talk a little bit about your affidavit. Is there anything in your affidavit that you feel is not accurate or reflective of your experience on November 10th?
No.
Objection relevance, Your Honor. This affidavit's already been excluded.
I would go 822 those affidavits.
The objection's overruled. The answer will remain in the record.
Did you ever talk to anybody from the state medical examiner's office about Amy Mullis's death?
No.
Okay. Nothing further, Your Honor.
Any recross?
None needed, Your Honor.
Thank you. You may step down.
Thank you.
Let's go ahead and take a morning recess for about 15 minutes. I'll see you back then.
Wow. Crazy morning so far on this one. Holy cow. What a sassy reaction to the objection. It's fiery. It's fiery because the state, here's my understanding. The state has investigated this guy, prosecuted the guy, convicted the guy, and incarcerated the guy. And he's tried every possible appeal, and I think this is his last-ditch effort. So they just want this to go away. They're a little frustrated, and that's why we see from the prosecutors just a little bit of snippiness, tiny bit of snippiness coming through. A medium screaming goat. It's medium quiet. It's not full loud. So Got the clothing color memo today. Yes, I got the memo. I just wear the clothes they tell me to. So Mrs. RA is not here today. She's gone, and she's going to be back, I think, tomorrow night with the kids. She just texted me and said they arrived at their destination. I think it's like, what was that, a 6-hour drive? 6-hour drive. So before the trip, we changed the tires on the car because we needed to change the tires before our trip back west. And instead, we didn't, and we waited. And now they definitely needed to be changed. So new tires on the car, and then safe for her to make the trip. So don't wear the same color shirt tomorrow. I'm just going to try not to just leave it on the floor in the bedroom. Because if Mrs. R comes home and there's like shirts and clothes on that won't be well. So, yeah, I've got my 2 oldest here with me as well. So they're in college, so they're doing college from home right now. Having a hard time believing, Barbara, this is great. I'm having a hard time believing she fell on the corn fork and then pulled it out and fell on it again. And the son knows something. Okay, here's what we know. The son found the mom. Okay, that's got to be traumatic. She was found unresponsive on all fours in the shed. And some people are saying, hey, that doesn't check out. I don't know how it checks out for everybody else, but having personally found someone deceased on all fours before, I can say it happens. I had to break into their house to find them deceased, but we did, and he was on all fours and had been there for quite some time. CPR was not an option at that point. So, like more than 24 hours. Peter Ware, member for 22 months. 2 months to Magenta. Love the journey. Peter Ware, thank you very much. Congratulations. One of our OGs. I love having you here. Thank you. Let's see. It's terrible. It is terrible. The son, I think, was 14 or 16 at the time. I think he was 14 at the time. I think he's still under 18. So maybe he was 12. He was the younger two were in the house and remained in the house the whole time. It was just the one who was old enough to help the family. He was 13. Man. Okay, so the son's 13, finds him in the shed. Dad goes out to see what's wrong, and Dad pulls the pitchfork out of Amy's back. He doesn't call 911. He runs and gets his truck, which, understanding where they were and how remote they were, if you wait for the ambulance to come, woo, 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 and then pick you up and then woo, 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 all the way back, that wastes a lot of time. So it's not unreasonable to say the best thing to do is start driving now. But he puts Amy in the car on his son's lap, okay? And starts driving in his truck to the hospital. Calls 911 in the truck. That's where we get that phone call that went down, where they say, hey, do CPR. So he pulls over. They start doing CPR, and the police meet up with them there. So, okay, the Cremo update. The Crimo case, what is it, Robert Crimo III? He was the shooter in the parade, the 4th of July parade shooter. Digging into that case, that is a crazy case as well. There's an update. I'm going to give that to you. That's why I've just jumped to that topic. Apparently, they just dropped 40 some odd counts against him. There were 7 deaths, and there were 3 charges for each death, and then there were like another 60 or so counts for all the injuries. If they dropped 47 charges, 47 happens to be the number that's tattooed on the side of his face, right by his eye. 47 is significant. It's if you think of the game or the movie, I think it's the game Hitman. Agent 47 is the 47th clone. He's a heartless assassin. 4/7 also happens to be the day and the month of the attack, the parade attack. July 7th. It would be quite interesting if they dropped 47 charges, because the defendant appears to be infatuated with that number. So they said he had a thing with the numbers 4 and 7. Yeah, so that's an update. That case, I think they're in jury selection right now. I don't know if the jury's been seated or not, but we'll see. But it's terrible. He got up on the roof and just started shooting a lot of people. Got a parade, and I don't think any. There's some video of that, and recording while you hear gunshots. I think he fired 60 to 70 rounds in that one. I wasn't ready for that case so soon. So, yeah. Yes, there was a political tie-in as well, and he had attended a rally or something. But wild cases. Okay, while we wait for the break to be over here in court, any questions we can answer on Pickles, not politics. That's as far as we're going in that one. But any other questions or comments on this case in Iowa? They said Monday was jury selection, then court TV and local news stations were trying to get into televised, but haven't heard if they're allowed. I saw local news stations say 117 charges. That might be right, because I think there were like 60 or so victims that were injured only, that didn't die. I think 6 died immediately, and 1 died in the hospital, and then the rest were all injured, because he was just spraying the crowd with bullets. He dressed up like he wore like women's clothing and a wig to sort of hide his identity, and he wore that during the shooting. It's really weird. Did you hear that Cheetos is coming out with a hot dill pickle flavor? Yes, and I'm looking for them. I have not been able to find that flavor. Please, somebody tell me where I can find Cheetos hot dill pickles. Yeah, that'd be great. Son's making macaroni and cheese for lunch. It's because we're all bachelors, with the wife gone. It's the bachelor pad. So make lunch out of a box. All right. Checked at local Kroger today and no luck. Late on the scene. What is this appeal for? He wants a new trial, but I don't understand exactly how Iowa works on this one. So I wish somebody who's really familiar with the Iowa legal system could tell me why we have this post-conviction relief hearing, which has been described as a civil hearing, meaning he's suing the state.
In front of the Walmart.
That's good timing there. He's suing the state because he wants relief from the fact that he didn't get his appeal granted, because his appeal was denied. The judgment, the preceding judgment, was affirmed. Of the court did the right thing in not giving him a new trial. So this is, I think, a last-ditch effort. But he does have some supporters. He's not just a crazy guy on his own. He's got family there supporting him. His kids, I think, are supporting him. We saw them there. I think his mom and dad are there, possibly some neighbors. And the way the state attacked this last witness, it's almost like that witness might be on his side as well. She was a friend of the family. They went to church together. They knew each other. Interesting. AM/PMs have the hot dill pickle Cheetos. AM/PM? Let's see. if we have an AM PM here. Sorry, I got sidetracked. I tried to search for it, and I searched for something else instead. Hey Siri, where is the closest AM PM?
Which
AM PM. It shows me 3 in California. Target has the hot dill pickle. Okay, I've got to tell you this. Just got a text from my wife. She said, made it safely on the bus and at Grok's command now. Grok is the Twitter version of AI. I had her use Grok to plan her itinerary for where she's at up in Virginia. And some old sites and tourist attractions and fun things. So she planned it, and she's like, this is amazing. Grok is incredible. She loves it, and she's got all the details. That was at 12:16. At 12:35, she texts, step 1, abandon the plan. Check. Grok is now obsolete. So they're done. They're like, we're just going to do it ourselves. So, Josh, thank you. I'll take a look at Mod Chat. See what happened here. Iowa legal post-conviction procedure. Okay, I'm going to read this. We're going to learn a little bit about how Iowa works with this. Oh, we're getting a call right now. That's going to interfere. Hang on.
Call from Oksana.
Hello, was this Oksana?
Yes.
Hey, this is RA. How are you doing?
Great. How are you?
Good.
So I'm calling because I watched it 3 years ago, I think it was, or
3 or 4.
Whenever, yeah, 3 or 4 years, and it was very interesting. I watched it carefully, every day of the trial. But I say I watch the trials. I actually just listen to them while I do whatever in the house. But the fact is that I remembered that case because I myself was very puzzled. How come they never, considered it being an accident? And to me, that's where my mind went, first of all, because I myself live in the ranch, and I know there's all kinds of very sharp materials everywhere, and it's always on the back of my mind to be very careful. And that, I believe, is a pig farm or something, so I can imagine they have a lot. And I think in the very first trial, they did show the video, the photos of the room where it happened. It's a very tight space. And if anything falls, it probably will fall on you. So you got to be really, really careful.
Now the problem is there were only 4 tines on the rake, and there were 6 holes in their back.
Yes, and I was thinking about it too, and it's possible that it was standing. And I'm not saying, but I'm just throwing it out there. But it was never even considered as an accident. It's possible it was standing, and she kind of kneeled over it or something. She leaned over it, and then it fell on her the second time. I don't know, but the fact that defense never even let that be an option was very weird. I do remember there was a witness who was the lover of the mother at that time, and they almost tried to question him in a way like maybe he was the one who did that or whatever. And I'm like, well, if you even throwing that kind of option out there, why not to consider it being an accident? And so I don't know. I think the fact that it was brought up is almost kind of I feel like, oh, okay, well, that's great, because it doesn't feel that weird anymore that I was wondering why they did not consider it as an option. It's also very weird to see his family, to see his boys in there, because I believe during the first trial, we only heard the audio of the deposition of the kid. Yeah. But they did not show him. So it's kind of interesting to see them supporting him, during that. And so that's the kind of thing. Oh, and also about the audio where he whispers something like, die, you, whatever.
Cheating whore, I think was the words.
Cheating whore, right. So it's kind of like it's a psychological thing because they introduced it as, you're going to hear him say that. Yeah. And then he goes, and it, you cannot help but your mind goes there that he says it.
You're listening for it. So your mind confirms. You're like, that's what I heard.
Exactly.
Yeah.
Yeah. But in fact, it's kind of like, it's not an evidence in itself because it's very hard. It could have been
more of like a 3 and 4 type thing instead of cheating whore. That could have been as he's counting the pressures. Yeah.
Yeah. And, also, one more last thing. It would seem to me very weird if he would ask his own son to go and check, who, and looks like maybe he was not a good husband, and maybe he did kill his wife, but it sounds like he was an incredibly great father because his sons were upset with mother, because everybody knew that she was cheating. And it sounds to me a little bit, far-fetched of a theory that he would send his own son to check on that, but especially, a son of 10, 12 years old.
Yeah, if he did it and sent his son to check on mom, that's not Father of the Year material right there. That's terrible. Yeah. All right, we're coming back right now. So thank you very much, Oksana, for the call.
Thanks so much.
Appreciate it.
Bye.
Bye. All right, here we go. Judge is back. The DA who left the courtroom was the lead prosecutor on Henry Dinkins' trial and also Molly Tippett's. He looked familiar, Woody. Somebody said the chips are on Amazon. There's no way I'm paying $20 for a bag of Cheetos. And you shouldn't either. I'm going to hunt for them and find them and pay the $4 or whatever it should be worth. I'm not paying $20 for a bag of Cheetos. Now, the Goldfish crisps that are spicy dill pickle flavored, that I might buy, but they're only $3.59. Had major doubts on this conviction last time. I see some major evidence hurdles for the defense, but it would seem wrong of them to come up and say, "Yep, it's clear this was a murder." That's a weird flag for the defense to wave to surrender in court. Check your Walmart. My local Walmart has them. Ooh. Speedway in Farmville has the chips. They're so good. Okay, I head up there. Oh, actually, I was just driving by there over the weekend. I should have stopped. I ordered my $8 Screaming Goat, though. Can I send them to your P.O. Box? We have them here. You can if you want to. I just don't want somebody to spend $20 on a bag of chips. That's too much to spend on chips. I'd love to find them.
Mr. Brown, you look poised maybe to
Mr.
get
Brown
a witness.
Is out of town.
Okay.
We are going to call Dr. Cruz, Your Honor. One thing we neglected to do earlier this morning, which we should have done, is to give the court the file of all of our exhibits, Your Honor.
Right, thank you. Good morning, Dr. Cruz. You've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
Okay. Go ahead and have a seat, please.
Thank you.
Ms. Thompson?
Thank you, Your Honor.
Whenever you're ready.
Good morning, Dr. Cruz.
Good morning.
We have not met, but my name is Kara Thompson. I'm one of the attorneys for Todd Mullis in this case.
Okay.
Could you please state your full name for the record?
My name is Kelly Cruz. It's Kellylykrusse.
I may be the only person that's having this problem. I'm a little here.
Sure, and I can't see. I'm sorry, there's no light on it, but
If you'd hit the, yeah, perfect.
Okay.
And Ms. Thompson, your microphone's not on either. There we go. That may help.
Thank you, Your Honor.
All right, with that out of the way, Dr. Cruz, you gave testimony in Todd Mullis' criminal trial back in 2019, correct?
correct.
And at that trial, you testified about the autopsy that you performed on Miss Amy Mullis back in 2018, right?
Correct.
And you prepared a report based on the autopsy that you conducted?
Correct.
In your trial testimony at Todd's criminal trial, you gave your opinions about the cause and the manner of Miss Mullis' death?
Correct.
And at that proceeding, you testified that the manner of her death was a homicide?
Correct.
And you testified that it was your opinion that someone struck her with a corn rake and that killed her?
I testified that she had injuries that would be consistent with those caused by the corn rake.
Was someone striking her with the corn rake and that causing her death?
Correct.
Those are opinions that you maintain today, Dr. Cruz, is that right?
Correct.
And you're not here at these proceedings to offer different opinions than the opinions that you've already given in your prior report and your prior testimony?
Correct.
You reached your opinions about the cause and the manner of Miss Mullis' death at the autopsy that you performed on November 12th of 2018. Is that right?
Yes.
And you based your conclusions about the cause and the manner of her death on what you learned at that autopsy, right?
Yes.
Is there any disagreement in your mind or any confusion in your mind that Miss Mullis was found with something called a corn rake that had been impaled in her back and her side?
That's information that has been consistent, so I don't have any reason to not believe that.
And it's also your understanding that after that occurred that she was rushed to the hospital, right?
Yes.
And that it was her husband Todd and her son Tristan who took her to the hospital?
That's what I've been told, yes.
And it's your understanding that they got partway down the road to the hospital when they were met by emergency medical services people who performed resuscitative efforts on Miss Mullis?
Yes.
And then it's those EMTs that then took Miss Mullis to the hospital?
Yes.
And she died at the hospital at 1:08 a.m.?
I'd have to check the time.
And sorry, I misspoke. She died at the hospital at 1:08 p.m., correct?
I would still like to check the time, but she died at the hospital.
Well, she died at the hospital?
Correct.
After she passed at the hospital, the medical examiner that was covering Delaware County at that time, Dr. Craig Thompson, he called your office?
Yes.
And he told you that he was sending Miss Mullis's body to your office for an autopsy?
Judge, I'm not object. These questions are all leading.
They are. Yes, I appreciate Ms. Thompson moving things along, if that's her intention in using leading questions. But since there's been an objection, if you could
I'd prefer them to be leading.
Rephrase and avoid using leading questions.
This was the subject of the pretrial motion that the applicant filed, and I do want to be heard on this issue. We filed a pretrial motion about this exact issue. We can take it up at sidebar or with the witness, but we filed a motion about this issue.
Okay.
This is background information anyway.
Did you want to take it up in a sidebar or just take it up on the record? Obviously, I assume you're referring to the issue of
the objections.
This witness being taken out of order.
I'm not. I apologize because I truly thought this issue was resolved.
Okay. I guess I'll leave it up to you if you'd prefer to take it up in the sidebar or just on the record now.
I don't think it impacts the content of the witness's testimony, so I'm fine for the witness to remain.
Okay.
The motion that we filed addressed a couple of issues. One, that this witness is an agent of the state, and as such, under the rules, I'm allowed to cross-examine her because she's not a hostile person with respect to the witness, but she's hostile for purposes of the rules. This is also relevant to the burden that Mr. Mullis has to prove at this hearing about what her testimony, what the trial would have been like with additional information, and she would have been the state's witness at trial, and she would have been cross-examined by trial counsel. So a cross-examination is appropriate regardless of who is proffering the witness. We certainly are proffering this witness. But the issue of her being an agent of the state alone makes it appropriate for me to lead her.
Any response, Mr.
Judge,
Brown?
this is a witness they're calling regardless of what her position was at the previous trial. These are leading questions. Developing an issue and asking leading questions in some respect is fine, but we're going to be getting into other details relating to Dr. Cruz's opinion. They're calling her as a witness. I think they should be made to follow the rules of evidence, so that's why we're objecting.
Yeah, this is a different situation. I don't think there's been an issue of establishing Dr. Cruz as a hostile witness in any sense. As far as her being an agent of the state, counsel, if you want to lay some foundation to establish, again, that agency relationship, something that would support or demonstrate a rationale for treating her as a hostile witness, you may do so. But for now, let's proceed as if she's your witness.
I'd like to lay some foundation for this issue, but it was my understanding that this was addressed in our motion and that this had been ruled upon. So I don't want to, this is an important issue for us, and that's why we briefed this issue and cited law and cited the statute, which says that a witness that's identified with an adverse party may be treated as hostile. And again, it's not about, obviously, Dr. Cruz's conduct on the stand, but her identity as the person that she is. I'll ask some questions on this topic, but this is an issue that for Mr. Mullis is important, and that's why we filed the motion that we filed. And we also discussed this at the pretrial conference, Your Honor, which is why, again, I apologize. When we addressed the issue of how the witnesses were going to proceed, it was my understanding this issue had been resolved.
Certainly. And I understand that there was discussion about calling witnesses out of order. And I think that there was clarity in that regard. I don't recall a specific discussion about this particular issue. And I certainly could be wrong. Counsel, maybe you want to chime in here.
If I may, Your Honor. Certainly, Rule 5.611 sub C for leading questions would not permit them normally on direct examination. And we have hotly contested, I believe, as the court knows, whether or not Dr. Cruz is in fact an agent of the state, because the state for this purposes under Iowa's PCR Act is the Attorney General's office and the criminal justice section. Most of the witnesses, if not all of them, would have been in their concept then a hostile witness and would fall under too broad a scope. Certainly Dr. Cruz has been openly answering the questions and trying to be responsive to them, and certainly there should be no reason to believe she's hostile yet. Now, should a finding of hostility be found later on, then maybe this could change, but the court has no reason to grant that right now, as she is not associated or called by us at this point in time, and the court's pretrial ruling was not in reference to this as it related to the pretrial motions.
Spicy battle here.
So the state would resist that finding.
Your Honor, our motion on this topic is at D0290.
you say 290?
Is that correct on it? Yeah,
From-
D0290.
From 20.
Defense has to win these arguments if they want
That's
to
the
stand
motion
a
to admit
snowball's
deposition
chance.
testimony, yes?
It addresses other topics as well, which includes being able to lead this witness.
And Your Honor, again, I don't believe that the court ruled on that, and that wasn't pertinent to this at this point in time either.
Why did the court not rule on a motion prior to this happening? Let me just say, this is the first judge's chair I have not been jealous of. It looks more like it was made of a converted stretcher or a backboard. It has a doily on it for cushioning. Judge is distracted. I don't know what other cases she has going on, but she seems to not be involved in this one.
Since it is just about noon, I think probably the prudent thing to do is take our lunch recess. We will excuse the witness for now. We'll pick up any additional argument on this issue that we need to over the noon hour, and then pick back up with the witness's testimony once it's been resolved and everybody knows where things stand. Dr. Cruz, you may step down.
Judge says, give me lunch to think it over.
Let's plan on resuming at 1:15. Counsel, if you can, well, why don't we take care of this right now?
Yeah, that'd be great.
If that works for you?
Yes,
right. Ms. Thompson, any additional argument that you would like to make?
Well, two things, Your Honor. One is, Rule 5.611 is very clear that the issue about leading questions is not just about, I mean, we all understand the classic witness who isn't cooperating in the exam, but that's not what Rule 5.611 speaks to. It speaks to and literally says the court should allow leading questions when a party calls a witness identified with an adverse party. And that is also, as we cited in our motion, what Iowa Code 624.1 says, which allows parties to call agents of public corporations and to treat them as, you know, they are a representative of the adverse party. And we can lay some foundation for this, but it's really undisputed that this witness is an employee of the state of Iowa. There is evidence in the record that she was being advised by Scott Brown as to her conduct in the pre-trial litigation of this post-conviction matter, taking advice and direction from the Attorney General's office about how to respond to the issues in this case. There's no question that she's identified with an adverse party, and so it's not about whether she responds to the questions in an appropriate way. It's simply that she is a person who is associated with an adverse party by the plain text of the rule and by the statute, and that is why we are allowed to cross her, Your Honor.
Just one more thing on this, and then I'll be done, if I may.
Go ahead.
So I'm well aware of the rule that is cited by counsel. But just because she is a state of Iowa employee or that she may have been called as a witness by the state does not substantiate the claim that she is somehow identified with us. The medical examiner goes to great lengths to remain neutral in their opinions. She is not employed by the Attorney General's office. They are completely separate. I would go back a little bit of a history lesson in that the ME's office used to be part of the Department of Public Safety, and they were moved out of the Department of Public Safety into to Health and Human Services, formerly the Department of Public Health, for that reason, so that they can maintain their neutrality. She gave an opinion that we utilized at trial. They don't like it, and that's fine. But that does not mean that this rule has been, that the terms of this rule would allow them to ask the leading questions in the manner that counsel is claiming she can ask leading questions.
May I make one more point of record, Your Honor?
Go ahead.
I mean, the offer of proof that we'll make, which we can elicit from this witness on the stand, is that shortly before Mr. Mullis filed his post-conviction pleading in this case, my colleague, Ms. Neshawat, wrote a letter to the medical examiner's office directed to this witness, giving this witness information about new material in this case and asking to speak with this witness. And the records that we have reflect that this witness consulted with the Attorney General's office, consulted actually with counsel to my left, and from that conversation determined that it would be inappropriate to speak with Mr. Mullis's counsel, and so she did not. And that reflects that she is taking legal advice or, direction in this case from literally the attorney sitting to my left. She did not communicate with us. She is not a neutral party in this litigation. And she remains an employee of the state of Iowa, whose office is in the same building as the Department of Public Safety, who is an employee of the state of Iowa, whose work in this case was in the context as an employee of the state of Iowa. So that's exactly what this rule talks about.
Spicy argument, and a good one by the defense. That last little tidbit of information might be enough to push it in their favor.
And the last thing I'll say about this, Your Honor, is were she not a person who could take legal advice and direction from Mr. Brown, and I do not say this to impugn Mr. Brown at all, it's inappropriate for an attorney in litigation under the rules of professional responsibility to advise a neutral witness not to speak with a party. That is one of the core rules of our profession, is that I cannot tell a witness, don't talk to the other side. The only way that it would be even appropriate for an attorney to do that is if that person can give that person legal advice because they are associated. And I certainly don't accuse Mr. Brown of having done anything improper. But the reason it was not improper for him to tell this witness not to speak to us is because they had a legal relationship. And so she's clearly identified with that party. If she wasn't, then there would be another issue that we'd be raising here in terms of professional responsibility, and we're not.
That's a good threat. Oh. That way, if you...
At this time, the state is not planning on calling her as a witness. Is that correct?
Your Honor, Dr. Cruz is listed as the state's expert witness and would be handled at the same time. To my knowledge, that would go to the court's pretrial ruling as it relates to the breadth of the testimony. I guess on the point of the breadth of this objection is, one, citing the rules of professional conduct in this aspect would seek to wrongly impugn an attorney's testimony here or an attorney's questioning here. There hasn't been, I believe, proof provided in this case, and perhaps I'd love to see it, that would suggest that there was some sort of impropriety. But beyond that, the deposition testimony that they sought to admit into the record already and sought stipulation to, for instance, regarding Dr. Cruz, they were, Mr. Mullis's counsel was completely comfortable asking open-ended questions there, and this sort of accusation would predate that. Again, we have extensively included in motions and resistances what the state means as a party here in this case, and this is just wasting the efforts. They certainly could ask about that in an open-fashioned way. Before this case proceeded, were you contacted by Mr. Mullis's counsel with new evidence? That can all speak to what Dr. Cruz did, but it certainly isn't shaping the purpose or why leading questions should be permitted here. And that is just too broad and too improper, Your Honor.
Type. Goes the judge.
Obviously, this isn't as black and white as it normally is.
Looks like we're going to get the lunch.
Because this is a PCR.
And there's already been the underlying criminal trial where some of these people have already testified as witnesses for the state. It's also not as black and white as it normally is because some of these people are employees of the state, albeit in different offices. And some of them have no other place to turn for questions than the AG's office. Looking not just at Dr. Cruz, but at the list of names that are included in the motion that was filed on February 3rd,
never had a leading objection go this long.
Obviously, I assume there are some different arguments for some of these other people, but specifically with regard to Dr. Cruz, the responsibilities of the state medical examiner are dictated and directed by statute and rule. They're not controlled by or directed by the Office of the Attorney General. In the absence of some foundation or finding that the state in this matter was directing Dr. Cruz's investigation or autopsy, I don't think she falls under this rule. So I'm not going to allow leading at this point.
So you're going to raise the other one about impropriety?
And I think generally speaking, it's probably going to be the same with regard to the rest of these individuals. I am assuming that similarly, there probably has been communication between these individuals and counsel at various points, but they are from different agencies. And you're free, obviously, to make whatever arguments you need to individually, whatever record you wish, either now or when we get there, but that's where things stand for now.
I understand the court's ruling, and I think, and again, we truly believed, and I say this only because I apologize for this coming up now, because it was truly the belief of every attorney for Mr. Mullis that this had been resolved at the pretrial conference, and that the reason we were agreeing to call her today was because we were going to be able to call her in our case and lead her. I understand the court's ruling. Respectfully, we disagree, but that's why we called her now. And I do think we need to confer briefly about what this means for us, because the appropriate examination for her, in our view, is this one, and if this isn't the examination the court is going to allow us to have, I think we need to decide whether we're going to have the state call her. So we need to make a determination about that, Your Honor.
Okay, certainly.
What if they don't call her?
We can, as I said, we'll take our lunch break at this time and plan on resuming at 1:15, and I'll be in chambers, so if there's anything that we need to talk about with regard to the schedule, you know where to find me.
Thank you, Your Honor.
Okay.
Your Honor, there's only one more issue that might be helpful to address before, while there's no witness on the stand. So just this morning, we were given a demonstrative exhibits for a witness that was initially identified earlier this morning that Mr. Mullis' counsel intended to call. These are demonstratives that were, to my knowledge, never provided to the state. 11 months ago, I believe the state did discovery requests, as the court knows, specifically requesting copies of any demonstrative aids intended to be used by Mr. Mullis's counsel or any of their witnesses. We received those exhibits, or demonstratives rather, at 9:42 a.m. today. It was never produced in discovery, and I know Mr. Mullis replied, because I inquired while trial was ongoing, whether these demonstratives were provided in discovery, and the response was that they got them this morning from the witness. However, given the late disclosure of these demonstratives, I believe that it is improper, especially considering this was a subject of months of discovery in this case and has resulted in numerous other motions related to the destruction or disappearance or what have you of other demonstrative aids. So I think it is an unfairness to the state to have additional new demonstratives, including highly technical mathematical calculations in them, and we can show them to the court if that would aid in your ruling. But I believe any demonstratives that had not been produced in discovery prior to the start of trial would be improper and unfair. Thank you.
Do these demonstratives go with?
I believe it's with Dr. Hammers is the only one that we've been provided thus far.
Can I respond, Your Honor?
You may.
All right. What counsel's talking about are two photographs. The photographs are photos of Ms. Mullis from autopsy, and they have some measurements on them that are pre-marked. Those measurements come directly from Dr. Cruz's notes that are on Exhibit 380, page 3. They are her measurements. This isn't something that is calculations. It's numbers. There's numbers written on a document that we intend to use with the witness. It's they're literally transposed from Dr. Cruz's notes. Well, a party is entitled to, make whatever interrogatory and document request they want in discovery. A party can't change the court's deadlines for providing materials by, asking for discovery that would require a party to anticipate, months and months, in this case, months and months and months before trial, every piece of paper they're going to show a witness at trial. There's not any new information here. It's literally a photo with numbers from Dr. Cruz pre-written on it. That's what it is. It's not a surprise. The idea of this being related to document destruction is, at that point doesn't make any sense. That's what this is. It's a photo with numbers from Dr. Cruz written on it. And we can lay the foundation for those numbers with Dr. Cruz.
And briefly, Your Honor, just to wrap this up, certainly I wasn't implying any document destruction was related to this. However, in reference to the counsel invoked the court's pretrial deadlines on giving exhibits, just this last Saturday afternoon, a day and a half before trial, we received a new exhibit that was never exchanged and never produced in discovery. And when I requested counsel specifically provide the day and time that it had been produced in discovery, no answer was given. So we would ask that the court put an end to the continuing production of new material and exclude evidence and materials that were not provided prior to the court's pre-trial deadline, which was 21 days before trial.
If somebody could please provide me with a copy of the demonstratives so I could take a look at it quickly over lunch, I will do so and let you know what we'll do with that. We'll see you back here at 1:15. Court's in recess until then. Your Honor.
Wow. This one's going to be spicy. It's going to be a battle from start to finish on this trial, this is a strange trial. First of all, I think we know who was sending the pictures, and I joined the Facebook group. I'll watch and see if there's any more. All right. In Iowa, thanks, by the way, Josh, for this. In Iowa, post-conviction relief is a civil action that allows defendants, that's the guy in orange, to challenge their criminal conviction or sentence after the appeal process is complete. So he failed the appeal. This is his next chance. A PCR, the post-conviction relief, can be used to address issues that weren't raised during the appeal, such as ineffective assistance of counsel. He said his lawyers did stupid things. He sort of raised that without saying those words. Errors by the court or prosecutor, unconstitutional conviction or sentence, newly discovered evidence, a new statute or case that affects the trial, sentence, or evidence. PCR proceedings are governed by Iowa Code, Chapter 822, and the Iowa Rules of Civil Procedures in these proceedings. The defendant is the plaintiff, and the state is the defendant. So it flips the roles, which means that the state, on most of the first part of the trial, gets to cross-examine all the witnesses the defendant calls. It's great. I love it. A lot of times prosecutors struggle with asking some good leading questions. PCR can result in relief such as a new trial, release, or modification of the sentence. So this is what could happen. It could be a new trial. He could just be released and be like, "You're a free man. Go live free. Go feed your pigs." Or modification of the sentence. Say, it was life sentence. We're going to cut it down to 10 years. We'll see what happens. Probably none of those. Some things to note about PCR in Iowa include PCR is not a substitute for any other remedies that were available during the trial court proceedings. You have to run through those options before PCR is even available. Applicants who are represented by counsel cannot file pro se documents in Iowa courts. Thank goodness. And cases may be dismissed for lack of prosecution, but can be reinstated within 6 months if the dismissal was due to a mistake or an oversight. Wow. I do have the audio, I think, from this trial. I'm just going to play audio for you, not video. Is that okay? Sound, HDMI. There we go. Okay, this might be a little loud. Let's listen here.
Okay. Now. I get 1, 2. 1, 2.
I'm backing up here. Okay. This is him being instructed by the 911 to do CPR. Okay? Over the 911 call. Their audio cut out.
Put the phone on. What do I do? Okay. Lay her flat as I can. As flat as you can. The heel of your hand on her breastbone in the center of her chest, right between the nipples. Okay. And place your other hand on top of that hand. Okay. Okay. Pump the chest hard and fast, at least twice per second, 2 inches deep. Let the chest come up all the way up between pumps, and we're going to do this until they get there and can assist. Okay. 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 Twice per second. I get 1, 2. 1, 2. My son is right here. It's private. Now. New house. The deputies are almost there. Okay. Keep doing the compressions until they can help and take over, okay? Keep going, you're doing fine. Okay. Keep going. Come on, respond. She's cold. Come on. Come on. Come on. Good. Come on. Well, Is the officer there with you, sir?
Yeah, he's here.
Okay.
It's, what is your name, Luke?
That's fine. Do you want me to stay on the line with you, or are you okay? Oh.
No, I can't talk on the phone.
Okay, all right.
My son's right here. I gotta.
Okay, all right.
Okay.
I think it needs some cleanup. I think we need to clean up that sound just a little bit. So we'll see what we can do on that. But the cutouts are the problem. I'm going to try to find a version that doesn't cut out periodically. And we'll go from there. All right, we have a new thumbnail up for the afternoon. Looks like Rianne K has already won the chat there, being first in chat. So the afternoon session after lunch, which I think is going to be about an hour, we're going to come back and continue this spicy legal battle with an almost sure outcome of you're going back to jail. Consider the odds are lower at winning this appeal than winning an appeal. And he already lost his appeal. Okay, this is almost an exercise in futility when it comes to the chance of success. But as they say in Dumb and Dumber, so you're saying there's a chance. Yeah, there's a tiny chance. Macaroni and cheese are ready. I already ate it all. It was just delicious. Thank you. Did the officers testify that he was doing CPR on her when they got there? I haven't heard. It sounds like, to my understanding, he was. His son was there with them. They were moving the seat, trying to lay her down. Said, move the seat back further. I think he was doing some sort of compression. So we'll see. We'll see if they go any further into that. Like 0.1% of a chance. Oh, Mel, broccoli cheese. The only thing better than broccoli cheese is Wisconsin cauliflower from Zupa's. If there is any one of you who have the money and desire to start a Zupa's franchise here in Greenville, North Carolina, I can guarantee at least once a week I will be buying Wisconsin cauliflower soup from you. I'm not sure if that's enough to make it worth it, but that's what I can offer. Zupa's is so good. It's one of the places I had to go to when we went back out west. Like, we're going to Zupa's. If I could take that intravenously, I think I would. That Wisconsin cauliflower. You'd have to cool it down a little bit, but because it would burn. But it is that good. All right. Was it Cracker Barrel? No, I think it was Western Family or Walmart brand or something. A Night at the Roxbury. I thought it was Dumb and Dumber. I might have misquoted my movie. I did not hear it the second time I played it. So I'm going to see if I can get a clearer version, then take out the background noise. Maybe over lunch. Does that work? Soup is so good. Had it last week. Oh, now I want soup. I have to figure out what to do for dinner tonight. It's just me and the two boys. I'm thinking pizza. Some homemade Little Caesars pizza. I don't know. We'll see. Have to slow it down as well. I'll tweak it. We'll get it working. Not cheese. Yes. Portal is automatic. Do stay here. Yes, as soon as you have to wait for the spinny wheel, and then don't go anywhere. Just wait. It will move you. It's just some things I have to do on my end to energize the portal, and then you all get warped over. We almost hit 1,000 likes. We were only 22 short, thanks to the 989 of you, 21 now, who clicked the like button. We were so close. You have that with milk? Oh, there's milk in it. Panda Express. Oh, can I have 2 things for dinner? Is that an option? Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again in just under an hour or sooner if they come back. Less than that. But I'm expecting the judge to make a ruling on this medical examiner. Or no, she already did. I'm expecting the defense to decide if they're going to rework their entire case because they don't get to cross the medical examiner. Thank you for 1,000. Woohoo! Party! I don't have the party sound effect. I just have the police. I'll do police as well. How about that? Yeah, you can hear him in the background there, right? Right. We'll see you guys after lunch. Have a great one.